seminar on the Insolvency and Bankruptcy Code. Friends, today we have chosen two topics, which is very practically is very relevant in this time. One is Limitation Act and its impact on insolvency law, where our speaker is Advocate Balbir Singh, Additional Solicitor General of India, Supreme Court. And our second topic for this day would be PF-related issues in CRP and liquidation. And our speaker would be Advocate Sandeep Bajaj. He is Managing Partner, PSL Chambers, New Delhi. So I would like to once again welcome you all to this session. But before we proceed for the session, let me clarify one thing, that this 3 CP hours is only for the chartered accountant who will be attending this virtual seminar. It's basically not the CP which is given by IBBI. So you must keep in mind while you can remain joined to this session, but the CP will be given only to our CA members as per the ICAI regulation. Friends, I would also like to place on record sincere thanks to the President Anup Kumar Sanghai for providing me this opportunity to chair this session on the Insolvency and Bankruptcy Code. Friends will be bringing before you various topics in the coming weeks also, which would be very relevant and very much required for while being the insolvency practitioner, or while being dealing in any of the aspect of the Insolvency and Bankruptcy Code. So our first topic our first speaker for this today's session would be Advocate Balbir Singh, and he would be speaking on the Limitation Act and its impact on insolvency law. Friends, over the years, actually, since the Insolvency and Bankruptcy Code has been enacted, there have been numerous judgments by the NCLT, by NCLAT, and yes, of course, the Supreme Court judgment, wherein different tribunal courts had held it differently. In you see all the aspects relating to whether the debt is covered under limitation, whether the Limitation Act would start from the insolvency enactment date, whether 3 years will be counted from which date. On many aspects, the threadbare discussion and threadbare hearings have been done at various courts and all. But right now, citing the recent judgment in Babulal Gujar case versus Veer Gujarat and Union, many of these issues have been settled, which our speaker will be dealing in detail. And recently also in one of the case in Supreme Court, which has overruled, or rather which has limited the impact of the 5-bench NCLAT order, which said that the balance sheet acknowledgement will not extend the limitation period. But after those judgments, which is also very good for insolvency and bankruptcy regime, which I think personally that all this speculation about the limitation and all might come to a final rest, wherein you see when limitation we will understand in a clear term, whether simply by the technological or simply by you see in technical method, you cannot say that a particular debt is not a debt, not a financial debt. Which I believe. And yes, in depth, we have with us our speaker who will be deliberating threadbare, or so that whatever confusion is there in our mind right now with respect to admissibility of the case during the insolvency proceeding with the Limitation Act might come to a rest. And then on the second topic, as we have with us Advocate Sandeep Bajaj, who will be speaking on the Provident Fund and ESI matters vis-a-vis insolvency law. Many of you are also practicing, I see many of you are also practicing under IBC as an RP liquidator and all. And we all must have received a notice from the PF department wherein they are on a continuous basis saying that the debt of the outstanding of the PF department or ESI department supersedes everything under you see every debt, whether financial, operational, everything is supersedes. And they are basically coming from a judgment in the matter of rainbow papers by the NCLAT. We said that irrespective of the irrespective of the resolution plan, whatever you say in the resolution plan, the amount due to or against the employees provident fund account would have to be paid in full. I mean, even including the penalty and interest, irrespective of that whether IBC has an overriding effect or not. And it clearly says that IBC is not in contravention to the PF Act. So this judgment has clearly created lot of confusion in the minds of the RA. I mean, in the Rainbow Papers Limited, even the RA Kusal Limited, he had to, I mean, by the Supreme Court, as the appeal was also filed, and Supreme Court has also dismissed the appeal, saying that they will not interfere in the judgment of the NCLAT. So now the RA will also have to think whether this judgment truly is a correct judgment or whether is in the spirit of insolvency and bankruptcy code. I personally believe is not what the intent of the law. But yes, let me not come in the middle of the learned speaker telling you the details about both the topics. And straight away, I would like to ask our deputy convener and co-chairman of this committee to kindly introduce our both the speakers and start and take forward this discussion further. And before that, before I hand over the proceeding to Sumit, I would request the participants to hold on with your queries. Either you can put the queries in your chat box whenever the particular speaker completes his allocated topics. We will direct the queries to him so that he can answer. So please bear with us till the time the learned speaker complete his allotted slot. Over to you, Sumit, for taking this session forward.
Yeah, thank you. Thank you very much. The president of HCA, Mr. Kumar Sangal, the co-speaker today, senior advocate Mr. Sandeep Bajaj, and Sandeep Bajaj for helping me to get Mr. Balbir Singh to see.
Sumitji, you can switch off your video.
Your voice is not audible, Sumitji.
Please switch off your video. I think there's a issue with net connectivity. You can switch off your video and then say.
Now is it better?
Perfect.
Yeah. So what I was saying is that we welcome Senior Advocate Mr. Balbir Singh, who is the Additional Solicitor General of the Honorable Supreme Court, and I am also thankful to Mr. Sandeep Bajaj, who has been instrumental in helping me to get Mr. Balbir Singh on board today at our platform. Thank you very much, Sandeep, for getting him. We at ACA are indeed grateful to you and also Senior Advocate Mr. Balbir Singh to consented to having shared time and which are valuable inputs to our participants today. I have a very pleasant task of reading the profile of Senior Advocate Mr. Balbir Singh. He had completed his LLB degree from Punjab University, Chandigarh in the year 1997. And thereafter, he practiced before Punjab and Haryana High Court at Chandigarh. From 2002 till date, he is practicing before Honorable Supreme Court of India, Delhi High Court, and other courts and tribunals in Delhi. Currently, he is registered with the Bar Council of Delhi, and he has appeared in more than 2,000 cases before the courts and tribunals till date. He also has the tag of being one of the youngest senior counsel in India. The Delhi High Court designated him senior advocate in May 2015 at the age of only 42 years. He's a member of the Bar Association of Delhi High Court, Supreme Court of India, and International Bar Association. And for the information of the participant, he's also a national level cricket player. So, which is indeed a rare feat, which we find in any of the advocates or senior advocates. He represented the Competition Commission of India as a standing counsel before the Competition Appellate Tribunal and Supreme Court of India in the year 2011 and 12. And he also represented the Commission in leading cartel cases like Cement Cartel, NSC MCX case, etc. He also represented the Income Tax Department as the senior standing counsel before Delhi High Court in the year 2012 and 13. He has extensive experience of 25 years in the commercial, regulatory laws, constitution, tax, including international arbitration. During his practice, he has appeared before the high courts in country and most of the statutory tribunals. He's also known for his knowledge of tax, including international tax, commercial disputes, and international bilateral, multilateral disputes, something, sir, which we chartered accountants also deal with. And prior to his designation as senior advocate, he worked with one of the leading law firms in India as a senior partner. In the role of partner with law firm, he extensively worked in on dispute relating to World Trade Organization for international clients. And he also carries a lot of international experience while being the member of International Bar Association, participated in annual conferences in Korea and Tokyo, recognized as one of the leading lawyers below the age of 45 years by a leading law research group in London, that is London Law Business Research, and the list goes on and on. Thank you very much, sir. Indeed, at ACA, we are really privileged to have your presence. And I once again thank Sandeep for getting you on board. Sir, the participants would definitely love to hear from you. We know that as a government representative, you have your own limitations, but definitely, I'm sure that you will try your best to satisfy the query of the participants through your deliberations and experience. Thank you very much, sir. Over to you, sir.
Thank you very much, Mr. Binani. I think that's a very kind introduction. And I can say that my track and my field has changed. I am no more a cricketer, but I play more in the courts, which you can equate with the tennis rather than the cricket field. So I'm more in the courts. So, but thank you very much. First of all, I think I must thank Association of Corporate Advisor and Executives for having me here. And certainly Sandeep is instrumental in it. Sandeep is a very dear friend. So I had no reason not to agree to it and certainly had to consent to it. But at the same time, I see it as a great opportunity personally for myself. I mean, to be among you, because ultimately, I personally think that any kind of economic law is more governed and practically regulated by the accountants of the country. And chartered accountants play a very, very critical role in the whole process. Now, we may see it from the development of law point of view, or we may see it from the stakeholders, which largely are your clients' point of view, to bring in the final conclusion or a closure, which may be in the form of resolution, or that may be ultimately in the form of dissolving the company and monetizing the company in the end. I think it is extremely important that the very efficient and educated people like you being part of the process that leads to a very well established insolvency process and law in the country. And I'm sure you have experience of earlier laws which we potentially can't call the insolvency laws, but there was efforts in the form of SICA, in the form of binding up, in the SARFAESI, and the other multiple, some state laws were there, where we were trying to achieve closure in one form or the other, but I don't think India met the success. And therefore, it was always, in my experience, one of the stumbling block for the foreign investors to see that if somebody is investing in the country, to close a company is a hell lot of a job, which practically becomes impossible, and liquidate a company and take whatever the assets or their capital out of the country was very difficult. But if we see post 2016, there is a lot of hope. But at the same time, I would say that the process has taken multiple turns where some are good and some are not so good. But I think this COVID has further added multiple dimensions to it. But I think going forward, it's extremely important that the law is laid down on the correct path. The objective of law is achieved, and ultimately the business thrives on it. And we don't see a large NPAs with the banks which are unrealized. We don't see the companies which are possibly can be a good companies, can be healthy companies, are dragged to these kind of processes. But ultimately, it's the responsibility of all the stakeholders, and I would say more of the accountants, because you are going to play a larger role in it. But coming to the topic of the day, I think if we see a limitation, not in context to IBC only, and generally if we see limitation, there is always a debate world around whether it's a right versus remedy. Limitation doesn't create any right. It is potentially considered as a remedy, and it is considered an equitable remedy around the world, because ultimately the objective is that if somebody has to face some kind of a claim, there should be some timeline and some certainty, and that's how the law operates. And because you can't foresee that any kind of potential claim is going to remain hanging for perpetuity, and therefore one can't plan the affairs on or the other aspects of the business. So if we see from the commercial laws point of view, limitation is always considered a remedy, not right. And as courts, when we'll move forward, we'll see that Supreme Court also has considered that this is more of a procedural aspect and not the substantial aspect of any law. But at the same time, sometimes the procedural aspect becomes such a dominant factor because it extinguishes or make alive a particular claim of a person under a different law. But if we see the object of Limitation Act is it's equitable, it's certainty and fairness, based on which through common law this is found a form of a statute in almost all jurisdictions. And if we see our Indian domestic limitation law, which is Act of 1963, broadly it is split in 5 parts. I don't think I need to get into too much of detail, but 2-3 angles which may be relevant when you finally look into your claims under Section 7 or Section 9 being treated by the NCLT at some stage under the code. These things may become relevant. Broadly, Part 1 contains 2 sections, which is largely the implementation and definition section. Part 2 deals with Section 3 to Section 11. Part 3 deals with Section 3 to Section 12 to Section 14. Section 12 to 24. So these 3 parts are the relevant parts which one need to see, because Section 3 is the section which talks for bar of limitation. So that's the section which blocks every kind of claim, and thereafter post Section 3 up to Section 24 are various methods by which how the period of limitation is to be calculated, how the period of limitation, if extinguished, is to be waived or to be recalculated. So broadly, Section 3, which provides a bar, and 4 and to 24 provides the different method of calculation. So far as the quantum of period is concerned, to determine that what is the period available for a particular kind of a remedy, there is a schedule which is given, which contain articles 1 to 37. And these articles are split in 3 divisions. Division 1 deals with suits. So Division 1 deals with suits, Division 2 deals with appeals, and Division 3 deals with applications. Because you must note that Limitation Act is primarily dealing with the courts. And when we say courts, that's the reason it deals with the suits, appeal, and applications. And tribunals are not considered being governed by the Limitation Act until unless there is a specific provision created under the legislation by which the particular tribunal is created. That may be Income Tax Act, that may be Excise Act, that may be GST Act. We will find that limitation, either a certain provisions are borrowed on these acts from the Limitation Act, or the provision contain their own limitation period, which is provided, let's say, for filing appeal, or let's say Section 147, 148 in the Income Tax Act, or Section 11A and 11B of the Excise Act, 28 of the Customs Act. We'll find that they have their own limitation inbuilt in that. So therefore, wherever these kind of financial legislations are there, and where the adjudicating authorities or the tribunals are not considered courts, the Limitation Act is applicable to a limited extent. And the courts over a period of time has interpreted on a case-by-case basis whether not the Limitation Act, but the principle of Limitation Act can be made applicable or not. Although this is an accepted position that the Limitation Act is not applicable to the tribunals, is applicable to the court. So the debate can go on distinguishing that what kind of tribunals can also become a court, or what kind of authorities can be court. But I don't think this is the time or forum where we should get into it. But that's a broad distinguishing factor which I'm pointing out. Now coming to the interplay of limitation law and IBC, primarily I think since you day in day out deal with it, the IBC's objective is not considered in law that it should be used as a recovery mechanism or a recovery tool. Largely the objective is to achieve a resolution. In case of failure of resolution, we step into the process of liquidation. That's broadly the understanding. It has got some interplay with the Companies Act also, because Companies Act, and primarily one reason why the Companies Act interplay, the corporate debtors or corporate creditors may have some kind of a statutory obligation under the Companies Act. And largely the two authorities, one is the tribunal, which is the adjudicating authority, and second is the appellate authority, which is NCLAT, has got a certain rights, authority, and certain statutory limitations coming from Companies Act also. And in fact, Supreme Court in one of the cases had occasion to consider that minus the limitation which was introduced in the IBC by virtue of 238A in 2018, whether the limitation law was applicable or not prior to that or in absence of that, the court took refuge to section 433 or 434 of the Companies Act of 1956 to say that since the NCLT or NCLAT potentially are tribunals considered in the Companies Act, therefore if under that law there is a limitation mechanism is provided or limitation is made applicable in the procedure, that can be read into the IBC also. But finally, the court was actually looking at that stage to newly introduced provision of 238A by which the Limitation Act was made applicable. So there is an interplay of multiple laws when we look at even the limitation mechanism under the IBC process. So therefore, I think anybody who's examining a limitation timeline while identifying position under Section 7 and Section 9, it's extremely important to see under the Companies Act as well as under the IBC that how the limitation period will be calculated and what are the rights which are affected under the Companies Act as well under the IBC. But if we see the why limitation becomes so important, the objective all around of the Limitation Act is to protect any kind of a claim which has gone beyond a particular time. And that time, as I said, is given in the schedule to the Limitation Act, can differ in case of where there is a right to suit, there is a right of appeal, or there is a right of application. So where any stale claim, like I'll call it a stale claim because something which is not enforceable in law becomes stale, whether that claim can be used as an event of default or claim or default in case of a particular claim, and therefore giving right under Section 7 and Section 9. That's the objective, that stale claim should not be permitted to bring in the process of Section 7 and Section 9. Largely, that's the understanding. And if we see, there are two dates which are defined under the IBC code. One is under Section 5, subsection 11, which is initiation date, and 5, subsection 12, which is insolvency commencement date. And then we see that over a period of, over the sections which are under the code, the one common thread which flows is that there are multiple timelines provided for different set of processes. Those processes may be from the resolution point of view or maybe from the liquidation point of view, because the objective is to achieve a time-guided, time-limited closure process. That's the whole objective. So the question arises that when the timelines are identified under the IBC, that maybe when we look at it, certain definitions in the form of claim, in the form of debt, in the form of initiation date, in the form of timelines for closure, then potentially there can be a certain conflict in certain situations with the Limitation Act. There can arise potentially. And this is one of the arguments which was raised in one of the cases. I'll come to that. But I think these two definitions are extremely important, because the one is the initiation date and second is the insolvency commencement date. So why so much of thrust on the date is that it has got something to do with the beginning period, because it must end in a certain timeline which are provided in the law. So these two dates are extremely relevant. If I just quickly go to next slide. Yeah, so I think I'll not get into what the position prior to introduction of 238A, except that there was a lot of confusion in the NCLTs across the country. In some cases, the view was taken that the provision of Limitation Act shall apply, and therefore the timeline was considered whether it's within the Limitation Act provided is there or not. But there is a contrary view which were also taken, saying the Limitation Act is not to be seen. And the first date, which is in December 2016, when the code was brought into force, that is the timeline, and within 3 years you can file a 100-year-old claim. That's the kind of understanding which came from certain judgments. Last, which created a confusion, was I believe is a larger bench of 5 members of the tribunal. They finally said that a Limitation Act is not applicable, but the principles of Limitation Act can be seen, and therefore those are to be determined on a case-to-case basis. That the adjudicating authority, depending on each application, can review the position, whether it's a claim is a stale or it's a maintainable, or whether in that case there is a sufficient cause for filing a late. But legal position taken was very clear that the Limitation Act is not applicable. Now, if we try and understand the difference between Limitation Act being not applicable, but the principles of Limitation Act to be applied, in those cases, there are not only the timeline is one issue under the Limitation Act, there are multiple issues where the timelines can be reset. There can be a certain delays or latches can be waived off. There can be certain waivers can be given under the Limitation Act. We'll come to some specific provision in that case. But while applying the principles of Limitation Act, that gives a broader discretion to the particular authority. And minus this 238A, potentially that judgment of 5 judges could have been interpreted by the different tribunal in different ways. But I think fortunately, that 5 judges, where was their 4:1 ratio, the judgment was passed, landed before the Supreme Court. But I think before coming to that, I think one aspect is important. We must see the definition, which was, or rather the section 238A, which was introduced. So I'll come back for a minute to section 238A. I believe it is on the second or third slide. Somebody else, sorry, is managing for me the slides. If you can come back, Naman, next one. Yeah, this is how it starts. It's extremely important that you must read this definition carefully, because you will be using time and again. It says the provision of the Limitation Act 1963 shall, as far as may be. Now this word as far as may be is extremely relevant. Now, otherwise these 238A could have very easily said that Limitation Act will apply to the proceeding appeal adjudication authority and rest so on and so forth. As far as may be, the reason for this is that in order to avoid any conflict with the timelines which are given in the code, if they are coming into conflict with anything which is coming under the Limitation Act, in order to avoid that position, the word as far as may be has been introduced in the 238A. And as I said, that the common thread which runs across the entire code is that there are timeline prescribed for different set of proceedings, including the closure of proceedings. So if there is a timeline provided under the code, that will have a prominence over timeline provided in the Limitation Act. That's the meaning of broadly of as far as may be position is concerned. So that's why this has been introduced in this fashion, and not blanket Limitation Act of 1963 has been made applicable. Now, I can give an interesting parallel to it under the Arbitration Act. What happens is when the award is passed, the award can be challenged before the court under section 34. There is certain timeline which are given, and those timelines are 120 days, which is 90 plus 30 days, and 30 days is assumed you can call as a grace period. Now this question again, and there is a specific provision which is there under the Arbitration Act, says that the Limitation Act will apply. In spite of that initial view which was taken prior to the amendment of 34 was that because Limitation Act is provided, and then therefore if there is a reasonable cause for delay in challenging the award under 34, then the courts have powers. But to take away this position and to see that the whole objective of Arbitration Act was to achieve a closure to any dispute where the parties have chosen to adopt a neutral venue or neutral arbitrator, then there is no point litigating it over a period of time in court. With this in mind, the section 34 was amended and the power of adjustment of time was taken away and period of 120 days was made sacrosanct. This position has been introduced in multiple tax laws in my experience, where the right to appeal, again, the question was that if you're filing before the Commissioner Appeal of Income Tax, CITA, or Commissioner of Excise, or GST, or Customs Act, there used to be earlier power to condone delay beyond whatever the statutory time was given to these appellate authorities. But over a period of time, the statute or legislation has frozen those times. Similar provision is there. We have under section 61 under the IBC code. I'll come to that when we'll deal with the appeal, whether the timeline provided for filing the appeal under section 61 is sacrosanct or whether the other provisions of a limitation act can be made applicable. Those kind of confusions still are going on because few courts have taken one view and finally Supreme Court has said that, but I think that in my understanding at some stage can be again reviewed, because the objective seems to be that once the right of the appeal, time for appeal is provided therein, whether the limitation provision should be read in such a fashion where you can extend the time and the power can be given to these courts or the tribunals to waive off the time, which is possibly is on delay on latches. So that's a separate question. But so this definition I wanted to read was, this was the position that why this word as far as maybe has been introduced in 238A. These two judgments which you can see on the screen is pre 238A introduction. These created confusion that Limitation Act will apply or not, principles of Limitation Act will apply or not, and what are the discretions which can be given to the tribunal while interpreting the principles of limitation and not even applying the Limitation Act. This created a lot of confusion, and result of this was that multiple time bar claims were used as window to invoke section 7 or section 9. And there was, in my understanding, and Sandeep is a better judge because he appears in lot and NCLT and I don't appear, but my understanding is that there were a massive number of claims which were filed across India based on this interpretation that the timeline of 3 years is to be seen from December 2016 when the code was introduced. And whatever time frame has passed prior to that, that has no significance or relevance to determine the period of limitation. But this was set right by the Supreme Court in case of, I think, Naman, you can, BK Educational Services Limited. This is a recent judgment where this issue came that there are two dates which are relevant. One is when this provision was introduced, that is in 2018, and the date on when the code was introduced, that is December 2016. So what is the position that you have to take, whether the 3 years can be counted from the date when the code was introduced, and that was the position which was taken by the larger bench, and whether the claims which were time barred can be revived by virtue of 3 years period to be calculated from 2016. Supreme Court said no, because A, this provision has been introduced, it is a clarificatory in nature, and therefore if something which has become stale or which has become time barred prior to introduction, let's say that NPA was declared in 2015, and or rather I would say 2011, in that case 3 years were 2014, and after that that claim become time barred. Can somebody say that because post the introduction of the code I'm filing, and therefore if I'm filing in 2017 or 2018, then irrespective of NPA being declared in 2011, I should be given a right to enforce my section 7 and section 9? The Supreme Court said the answer is no. And if you see the facts of this particular case, as you can see on the screen, the two dates are relevant, and the two dates I have given is 6/6/2018 is when the provision is introduced, 1/12/16 is when the code came into force. And in this case, NCLT had said the Limitation Act will not apply, and 3 years can be seen from the date of 1/12/16. That's what I said. The court, while examining this aspect, looked into a law committee report of 2018. This report is extremely important. government was watching that the NCLTs across India are taking a position which are contrary to A, the understanding of law, and second, they were creating a conflicting position by virtue of which multiple claims were filed across India. Some were entertained, some were disputed, some were dismissed. Now, in the law committee report, it was made clear that A, the objective is not to allow stale claims to be enforced through this mechanism by this way of interpretation, because there is no limitation act applicability in case of IBC. Second, they say that the committee notes, rather, based on multiple judgment, that what is relevant is a default, and second is the amount is due. Now, courts over a period of time has said that if something which is expired by virtue of time or efflux of time under the Limitation Act or limitation law, that is not considered due anymore. So the right is lost. And once the right is lost, then you have no right to sue. And consequently, you cannot resurrect that right by virtue of the code being coming into force in 2016. That was the understanding, and court examined this position and finally said that no, a stale claim cannot be entertained. However, the court specifically said that if there is some delay, let's say that somebody has filed a claim which has got delay of 10 days, 15 days, 7 days, or whatever, but there is a sufficient cause to justify that there is a delay. Now, this concept of sufficient cause again stems from Limitation Act, because Section 5 of the Limitation Act says that if you have filed any application, any suit, or any appeal beyond the time prescribed in law where the Limitation Act is applicable, and you have a sufficient cause to show to satisfy the court that because of XYZ reasons, you were unable to come to the court in time, in that case, court can utilize its power under Section 5 of the Limitation Act. So therefore, the court, while holding in this particular case, said that A, Limitation Act is applicable, B, it is clarificatory in nature, it is applicable from 2016. Once the Limitation Act is applicable, the benefit of Section 5, which is sufficient cause and satisfaction of the court, can condone certain delay. So that is finally said in the court. So you can see that what finally has been done on this screen is, one is the Limitation Act applicable to 7 and 9. The interesting part was that how do you govern the period of, how do you calculate the period of limitation in this case? Article 137 of the Limitation Act, which applies to application under the Limitation Act, which is given in the schedule, that prescribed the period of 3 years. So this was again important finding by the court, that Article 137 of the Limitation Act will apply while calculating the limitation period. Right to sue is to be seen from Section 7(9) point of view when the default occurs. So that was the another aspect. Third, I think we have already talked. So these were broad 3 principles laid down by the court when the court examined this aspect. One interesting aspect in this which court noted, and I think it may be helpful to you since all of you are practicing this. Court in this particular judgment in para 19, you can use it if you at some stage maybe use. Court used Section 433 of the Companies Act of 2013, said that this will apply to the tribunal even when it is deciding application under 7 and 9 of the court, which means the court said that even if you read minus this new introduction of 238A, NCLT being a tribunal which is functioning under 433 of the Companies Act, whatever the timelines given therein can be read into Section 7 and 9. So therefore, court had gone to the extent of, this is an interesting observation in my understanding, court used the provisions of Companies Act 2, which were made applicable or considered for the purpose of Section 7 and 9. So that is in a BK Educational Services. Now, up to this position, it became clear that Limitation Act will apply. Article 137 gives a 3 years period that will apply. And Section 5, which is sufficient cause and satisfaction of the court, that provision will apply. Now, this opened a Pandora's box because, as I mentioned, that Limitation Act is not only about calculating the period in terms of schedule, which is given under the Limitation Act. It applies in case of reset. When I say reset, a debt which is due and it is due for a period of 3 years by virtue of limitation, and thereafter it is not due anymore. Can it be reset or can it be rolled over? The answer is yes, but there is a certain methodology which is provided under Section 18 of the Limitation Act, which we'll specifically see 18 because that is going to be relevant. That's the one aspect which left open. And as I think one of the person who Ms. Loya, who introduced the whole session today, he specifically pointed out that what is the due date? Can the balance sheet entry be treated as a acknowledgement of debt and so on and so forth. So acknowledgement concept of 18 became open and different views were taken by different authorities. One more aspect which became open is the small Roman 2 on the screen was Section 14. Now the Section 14 says that if you are before a wrong forum, chasing to recover your money from the borrower or the corporate debtor, then if you later on come before the IBC court, the time spent before the wrong forum should be waived off for the purpose of calculation. That's broadly the essence of Section 14. These kind of proceedings start happening, and this came before the court. And as all of you are aware that the IBC came since 2016, and all these the claims were under litigation from the bank side or the lender side or from the NBFCs and so on and so forth. These were pending at multiple places. That may be in the DRT, that may be under the SARFAESI proceeding, that may be in the winding up proceeding under the Companies Act. And one of the provision which was introduced, the lot of pending winding up petitions were transferred to these NCLTs across the country, and therefore their winding up petitions were treated as Section 7, and independent assessment under Section 7 were made for the purpose of treating them as an initiation of IBC or CIRP process. But now these 3-4 sections are extremely important to examine when we see that. First is, if you see Section 5, this Section 5, as we said, there are two features of Section 5. I don't think we need to read it. One is that there is a satisfaction of the court, which is extremely important. So the word is satisfaction. Second is the sufficient cause. So if you are able to satisfy the court for the sufficient cause, in that case, their period can be extended. So whatever the period provided for in Section 7, because court made Section 5 applicable to these proceedings, you satisfy the court with the sufficient cause, that period can be waived off or can be added to your period of limitation, or this way it can be extended. So this Section 5 is extremely relevant in the IBC proceeding. Second is Section 9. Now, law says the period of limitation in case of any kind of a claim is a running horse. You can't stop it, or it's like a bullet shot by you. Once, rather the provision reads, where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. So it is very clear that if you have any inability to file a suit or make an application to stop it, once it starts running. However, there is a process again which is within law. So once it has been, a time starts, which means that it became due, or let's say that the NPA declared by a particular lender. In that case, that can be a time frame or a certificate issued by a particular lender. That becomes the start point. That becomes the trigger point based on which the time start kicking in. So that's again, you have to keep note of. Section 14 is another aspect which you need to note. Now there are the subsection 1, which it talks of computing the period. And as I mentioned earlier, if you read the two major parts of the Limitation Act, the part 1 is contains Section 1 and 2, part 2 contains Section 3 to 11, and part 3 contains 12 to 24. So 3 is the provision which says there is a bar of limitation, and 4 to 24 provides that that how do you compute the period of limitation, and 14 is extremely relevant in the whole process. This says that while computing the period of limitation, if the suit is filed before a wrong forum, which has no jurisdiction. The important is that if somebody has gone before a wrong forum, which has no jurisdiction, in that case, that period can be excluded. Now, so therefore, one has to satisfy that if somebody has gone to a court for making a recovery, and that court was not a right court, or from the jurisdiction standpoint, or that court was not competent to give or pass any order to resolve the dispute for multiple reasons. Territorial jurisdiction can be one. Now, in that case, the period which is gone before this wrong forum, now that period can be reset or can be included in the period of limitation while computing the period of limitation. So subsection 1 deals with the suits, 2 deals with the application. If you see in computing the period of limitation for any application, the rest of the provision is the same. So therefore, somebody has filed a winding up, somebody has gone to DRT, somebody has got in the SARFAESI, the time spent there, can you calculate that time to say that that time should be excluded because I was pursuing a remedy before a wrong authority or wrong forum, and therefore when I file section 7 today or section 9 today, please don't include that period in the period of limitation, and therefore please allow me to minus or subtract that period which I spent before the wrong forum. These kind of issues came before multiple forums, including Supreme Court. We'll come to that, but this is section 14 is relevant from that standpoint. Now, the next provision which is relevant, which is a rollover period, is the effect of acknowledgement in writing, and that's what where the Supreme Court recently introduced that. How do you reset the period? How do you roll over the period of limitation? The period is 3 years, but before the ending 3 years, if you have got any kind of acknowledgement in writing, then that becomes a fresh start of the period, and therefore you can keep rolling over subject to the satisfaction that there is in writing signed by the party that such property or right has not extinguished, which is the claim has been made has not extinguished, which means that before the expiry of limitation period, it has been reset. And one of the very prominent the argument which has been taken all across, which has been recently settled by the court, that if somebody is showing in the balance sheet on 31st March of a particular year that this amount is outstanding or this amount is payable, whether that's a reset or that's an acknowledgement. Supreme Court said yes, but we'll come to that because there is a few aspects in that which requires. So these 4 provisions are extremely relevant that one should take note of when you see any claim, any default for the purpose of section 7 or 9, and also when RP or the committee of creditors are entertaining claims. So these principles will apply not at the entry stage, which is 7 and 9, also at chapter 2 or chapter 3 stage, where your CIRP process is finally to be enforced, or in absence or in failure of resolution process, one steps into the winding up process or liquidation process. At that stage also, these periods of limitation are going to be extremely important, or the provisions of limitation are going to be extremely important. Now, this is broadly in my understanding that the provision you should take note of while seeing the interplay of IBC and limitation. Now, there are a few interesting case laws which you must take note of. One I have already pointed out, where section 238A, which for the first time in 2018 introduced limitation period, that was interpreted by the court and provision was made very clear. The another important aspect is that in Jignesh Shah, which is again is 2019 decision of the court. Now, this is again an interesting aspect, but I would say that marginally this has been deviated in one of the cases later on, but in my understanding, this lays down a correct position. Now, just to see the facts of this particular case, which are extremely important. MCX sold certain shares to ILFS. ILFS became the shareholder with the condition that ILFS share, which were held, MCX share, which were held by ILFS, will be bought by a MCX group company called LAFIN, which was a group company of MCX. Now, LAFIN was asked to purchase shares which were held by ILFS, and Laughton refused to entertain that right, and therefore refused to purchase the shares from ILFS MCX share, because by that time MCX has gone down by virtue of multiple investigations against them. So Laughton refused. So the option with the ILFS was one, if you see in the third line, they filed a suit for specific performance on 16/6/2013. So that's the first step remedy which they took. They filed a specific performance suit. Second position was they filed a winding up on 21/10/2016, which is in the first line, which is given under 433, 434 of the Companies Act. Now, when IBC was introduced, in spite of filing a specific performance suit on 16/6/2013 and 21/2016, IBC proceedings were initiated and Section 7 application was filed on December 2016, 1st of December 2016. Now, this was in the form of a transfer of winding up petition by virtue of introduction of IBC. So this was not technically filed as a fresh petition, but this was a transfer of winding up petition. This winding up was converted to Section 7 petition, and this Section 7 petition was admitted on 28/2018. Now, this admission was objected to on the ground that the winding up which was filed was barred by limitation, because this right of purchase of shares the obligation of purchase of shares by Laughton was, I think, in 2011 somewhere. Now, the issue arose that if the winding up was barred by limitation, can a consequent transfer turning it to an application of Section 7 can be valid and can be filed or not? The court, after considering the pending DRT proceedings, provision of Surface Act, but the court said that these are independent proceedings. While examining a petition under Section 7, a limitation is to be satisfied. And if the limitation the limitation requirement is not met, which means that if the claim or the event of default is barred by limitation, then Section 7 is not maintainable. So the Section 7 petition, which was admitted in the 2008, finally Supreme Court said that your suit for specific performance was filed in 16/6/2003. Winding up was filed in 2016. Therefore, your winding up which was filed was found to be time bar. And consequently, this time barred winding up petition transferred to NCLT by virtue of introduction of code is again barred by limitation, and therefore it cannot be treated as a valid petition under Section 7. And finally, court held that Section 7 is not maintainable and dismissed. Now, there's an interesting mix in this, because there are a lot of arguments which were raised. That you have filed a suit for specific performance. Potentially that someone can say that I was before a wrong forum. B, you have filed a winding up petition, and winding up petition, rightly or wrongly, let's say, was admitted by the High Court under the old provisions of the Companies Act. Now, since that exercise has already been done, by virtue of transition provision, this is being transferred to the NCLT. Can you judge at that stage a fresh limitation exercise, and therefore to determine saying that that winding up when was filed by bar of limitation? That argument can be raised and been raised subsequently also. We'll come to one of the judgments later on. Now, that position being taken here, the court was very, very clear that all these are independent remedies. If you have taken an independent remedy, then still if you are going for a fresh remedy, which is Section 7, maybe by virtue of fresh application or by transfer, in that case also you need to satisfy the period of limitation. And in this case, since your winding up, which was originally filed before the High Court, was time barred, therefore Section 7 goes out. So therefore that's the view taken in Jignesh Shah. So that's the again a period of limitation is extremely important. Second important part is that this is the Padma Kumar was the larger bench judgment. Here 4:1, as I earlier mentioned. There were two components in it. One is whether the balance sheet is acknowledgement or not, and that one more aspect was raised in this. The other aspect was this has been overturned by Supreme Court. So let me come to straight Supreme Court. I think I have noted what the second aspect was. I'm just skipping that. Now, can you come to the last, because this was an aspect on the balance sheet in the last judgment of the Supreme Court, where Justice Nariman, I think in 2021, is April or something which has come up, I believe is the last one. Yes, Bishal Jaiswal and others. So this position of 4:1 ratio of a larger bench came before the Supreme Court. Now, if you see the facts of this case was, there was a borrowing by CD from a consortium of lenders, and SBI was in lead in that case. This loan was assigned to ARC India Limited, who became ultimately the appellant before the Supreme Court. In this case, the appellant issued a SARFAESI notice on 20th of May 15, physical possession taken in June 2016. And then when the code came into picture, the application under Section 7 was filed on 26/12/2018, and this was admitted on 19/2/2020. Now, in this case, the argument taken was whether the date of default can be drawn from the balance sheet, whether it's a valid confirmation. So the first point now was whether the balance sheet can be a standalone basis can be considered as due. That was the first examination. The larger bench of NCLT in Padma Kumar said that answer is no. Before the court, the argument purely to determine saying that this is a valid confirmation, argument of Section 18 was used, and Section 18 was that it is being acknowledged, and therefore if it is showing in a continuous 5 balance sheet, it means it's being rolled over and the requirement of Section 18 is set up. Now, this position was taken and the court agreed that yes, it is a case of rolling over, and two things comes out of this: a valid confirmation, and second, it's an acknowledgement for the purpose of Section 18, which means that the period of limitation gets reset. And finally, the court said that Section 9, in spite of looking at that, I said that Section 9 is a running horse. In spite of noting Section 9, the court read Section 18, which is a rollover provision, and said that Section 18 is not creating any new right. You always had a right. Every balance sheet, if somebody is acknowledging on 31st March, then in that case, it becomes a rollover. Or rollover means the acknowledgement. And therefore, that satisfies the requirement. If you continue to roll over for 20 years, on a 20th year, you can file Section 7 and say, because this is being acknowledgement and therefore it's not barred by limitation. So this aspect is purely from the point of view of A, the identification of debt or a valid confirmation, and second, from the acknowledgement point of view. This is what recently Supreme Court said. But there is a one aspect, I think, again, because all of you are accountant, is important to read. There is a one para which gives a certain kind of a caveat or a protection, which all of you must take note of. I'll just read, it's only 4 lines. In this case, one of the argument raised was to say that please don't treat the balance sheet entry as acknowledgement, because I prepare a balance sheet by virtue of provision of the Companies Act, and Companies Act is a force of law or a coercion by law. I am forced to make those entries, and therefore it is not a voluntary act of acknowledgement of that. That's an argument which was raised. Court negated this argument for 2 reasons. One, the court said that Companies Act may be asking you to prepare a balance sheet. Companies Act is not asking you to prepare a content of balance sheet in a particular manner. Whether you acknowledge or not acknowledge, that's not a force of law. You have to prepare a balance sheet. What you add or subtract from the balance sheet is not something which is provided in the Companies Act. That was argument number 1. Second, court said that once, even if it is treated by a force of law, it is being acknowledged or recognized for the statutory scheme, then it can't be said that it's not an acknowledgement for the purpose of Section 7. However, court was conscious that if we look at the auditor's report, or we look at the director's comments given the report, There was a caveat created in para 16 of this judgment, which I'll quickly read because this may be relevant for all of you. This says, importantly, this judgment holds that though the filing of balance sheet is by compulsion of law, the acknowledgement of a debt is not necessarily so. In fact, it is not uncommon to have an entry in the balance sheet with notes annexed to or forming part of such balance sheet, or in the auditor's report, which must be read along with the balance sheet, indicating that such entry would not amount to acknowledgement of debt for reason given in the said note. So this is a window which is given in this judgment, that when you are signing a balance sheet for your client, and if you think that there is a threat of Section 7 or IBC proceedings being initiated against your client, for multiple reasons, you have to make that entry, because that's a reflection which is already made in the books of account as the money has been borrowed. There can be a separate notes to account, or the auditor can qualify that it is not to be treated as acknowledgement for the purpose of Section 7 or for the purpose of Limitation Act. Then in that case, you get over with this judgment of Bishal Jaiswal. That's what the window which is given in para 16. So this may be one of the relevant aspects from the standpoint of balance sheet to be treated as acknowledgement or not. So that's another important judgment in recent times which has come. It's a very recent, I think it's 15th of April this has been delivered. Naman, can you please go back to just go one behind? I think 2 or 3 judgments are left. So Padma Kumar we have covered. Then yeah, correct. Babulal Gurjar, this was, yes. In this case, 2 arguments were raised. One argument was similar to the earlier argument. This is also again in August of 2020, the judgment is being given. That limitation period will start from the date when the code was incorporated, which was 1st of December 16. And second argument was, in this case, borrowings were secured by a mortgage or property. So the security was through a property. And in that case, the argument was that please don't apply Article 137 of the Schedule of Limitation Act, but apply 60 or 61, where there were 12-year period was given for the purpose of mortgage or security suits. That was another argument was raised. In this case, again, the court relied on BK education and held a default begin on the date of NPA or recovery certificate. There is no concept of continuous default and the date of default freeze. So one is, the argument was raised that if there is a default and interest is accruing on a regular basis, although it's specifically captured in the loan document, in that case, court said for the purpose of Section 7, there is a freeze on default date. And therefore, that's the date when you do kickstart. So that's the first observation which was made by reading BK education. Second in this case was, although it was not examined in detail, and I also don't know unless I see a particular facts of the case, court, sorry, you could go back to the first one, the earlier one. Yeah, if you see the second part, the court did not agree that Article 137 is not to be read and rejected the argument of 12-year by reading Article 60 or 61 of the Limitation Act. Court said no, in BK education it has been settled that Article 137 is to be read, which gives the period of limitation of 3 years. And therefore, even if a security is created by virtue of underlying the security being property, therefore, still the Article 137 will apply, which means that court refused to entertain the argument of 3 years versus 12 years, and they finally settled that Article 137 will apply. This was the position taken in the Babulal Gurjar. Yes, the another recent, all these are Supreme Court decisions. Why I'm reading all this is because I may not be aware of what is going on in the NCLT or NCLT in so many proceedings. Possibly Sandeep is a better person to answer this. But broadly, this is a position taken over a period of time by Supreme Court. Now, this is also, again, an interesting case. Is decided very recently in March of 2021. And this is the only case, at least before the Supreme Court, where this dispute of limitation period calculation came not at the entry stage, which means not at the section 7 or 9 filing stage. This came at the resolution plan submission stage. In this case, the resolution plan was invited, or applicants were asked to file resolution plan. The one specific party, which is Kalpraj, filed a resolution plan after the cutoff date. And after the cutoff date, it was filed, and this resolution plan was submitted before the adjudicating authority by the RP. In that case, the NCLT took a position that this is a valid plan because it was apparently was most beneficial out of all. So they upheld or approved the plan. Against that approval by NCLT, the other applicant filed a writ petition before the Bombay High Court. Bombay High Court saying that the A ground of natural justice and so on and so forth. After keeping it pending for some time, the Bombay High Court dismissed, saying that you have an alternate remedy of filing appeal before the NCLT under section 61. Therefore, writ petition is dismissed. Now, they came in before the NCLT. NCLT in appeal said two things. One, they said that the period which is used for filing a writ petition can be waived off, and therefore the appeal can be maintained. However, and yes, I believe it was sent back to NCLT. And if we see third para, the interested party filed before the NCLT, but was filed beyond the period of limitation under section and the corner extended the period of 41 and entertained the appeal on merits. So it says the borders of NCLT. Yes, the NCLT had sent it back to NCLT. This decision of sending it back to NCLT by entertaining the extended period of limitation and setting aside the original NCLT on merit came before the Supreme Court. Kalpraj challenged this by saying that the period which is waived off, which was spent before the Bombay High Court, should not be excluded because section 61 is a part of a complete code in itself, and the appeal is to be filed within the time frame given under section 61. Supreme Court said no. Whatever the time frame which has been spent while taking the remedy of writ petition before the Bombay High Court, that can be waived off. Therefore, the period of limitation is to be seen by excluding that period. However, finally, on merits, the court agreed with the NCLT order, and they finally accepted the NCLT position. From limitation point of view, what I'm trying to point out is that at the appeal stage, if you have taken some time, which has gone before any other forum, whether that is to be taken into account for giving you a leeway for filing the appeal beyond the prescribed period, unlike in section 34 of the Companies of the Arbitration Act, where the 34th challenge of the award is a sacrosanct and you can't go beyond a single day outside 120. Whereas in Supreme Court has taken a view otherwise so far as the appeal under section 61 before the NCLT is concerned. This is the outcome of this. Yeah. Sheshnath is the other case which came recently before the Supreme Court. That came in the March of 2021. In this case also, broadly the issue, or rather the situation was similar to the earlier matter. In this case also some dates are relevant. If you see the 4th or 5th line on the date of default or right to sue accrue for the first time on 31/3/2013. So that's, if we treat as a default happening on 31/3, or the kickstart date is 31/3/2013. SARFAESI proceeding was started on 18/1/2014. These proceedings were stayed by the Calcutta High Court on 24/7/17. The matter is still pending. Thereafter, all this, the section 7 was filed on 10/7/18. SARFAESI proceedings the question was, the SARFAESI proceedings were within jurisdiction or without jurisdiction. Court, while examining the position of section 238, specifically said these words, and these words I think are extremely relevant and as far as applicable. And why I was initially insisting as far as applicable is, court in the end said that if we read the object of the code, and if we see somebody is pursuing a remedy before a winding up court, in that case, the principles of section 14 can be applied. That's broadly the position which is taken, which means that you're pursuing a remedy before a wrong court. That benefit was given. But if we closely look at the requirement of section 14, there are two requirements in that. In case of suits and in case of application, the subsection 1 and subsection 2 are separately identified. And if we treat that our case is case of application under 2, somebody need to satisfy that A, before your earlier proceedings were filed before a court which had no jurisdiction. In this case, when the winding up petition was filed, this was not examined whether the winding up court was court of valid jurisdiction or not, or that the winding up court was in position to pass or afford certain benefits which possibly a jurisdictional court can extend or not. That was not examined, simply considered by saying that because it was pending before the winding up court and therefore principle of section 14 was applied. That was, to my mind, a little vague situation there. One or more aspect which was examined by the court in this was that section 14 will apply in those cases also where the proceeding before the earlier courts are not terminated, which means the proceedings which are still pending, which means we may not know the outcome of the first proceeding. However, when we are going before a fresh forum like IBC under section 7, we want to take benefit of exclusion of time which has been spent before an earlier court, which is a winding up court, although which are still pending. Can you still take the benefit of time which you have already spent, and you may have a further additional time going in there, and the further some remedy or some order may be passed which is affecting the proceedings in the first court or the winding up court? Can that benefit be given in such a situation? Court, after examining some different statutory schemes, came to the conclusion that if we read section 14 and particularly the explanation to section 14, it is not essential that the earlier proceeding before the first court should be terminated so that before the second court or the second proceedings like section 7 before the IBC, that time is to be excluded. The broader understanding, if we see the majority of judgment, says that how do you calculate the time spent before the court which had no jurisdiction is because there the proceedings have closed. Here the court said that is also not required, even if the proceedings are going on. And those proceedings, so this is, in my understanding, is a more of an equity-based judgment where the object of the act has been seen to finally give a relief and said that section 7 is maintainable. That's the final view has been taken from the limitation standpoint. Broadly, I have, I think, covered most of these aspects of limitation, which may be relevant from the highest court point of view, which is Supreme Court view, which has recently been taken. There may be certain aspects which I may not have covered, which I possibly may not be also knowing because these are maybe going at the NCLT level. But if anybody has got a question, maybe either I can try and answer those, or maybe Sandeep can answer if anybody has got any query on this aspect. So I'm great.
Thank you. Yeah, thank you, Balveer sir. I mean, it was a wonderful aspect. So you have almost covered all the aspect of Limitation Act. I mean, you see, as a chartered accountant, I mean, we have learned the limitation law from the scratch actually, and then finally understanding the very important judgment of the Supreme Court. But sir, one question before I throw the house open for the questions. Yes. One question actually, it has also come to the chat box also, whether this Limitation Act is also applicable to the professional who is acting as an IRP, RP or a liquidator while correlating the claim. Whether he has also to see that whether the claim which has come before him either during the CRP period or during the period of liquidation, whether he can decide on the limitation aspect. So this I want.
If we see your statutory scheme under IBC, RP's role basically, unlike COC's position, is just to collate the claims and finally to present it, and therefore adjudicating authority to look into. But looking at, there may be a voluminous claims, there may be a numerous claims which are filed. Broadly, if out and out something is barred by limitation, the answer is yes, RP can apply limitation, because ultimately, if a claim is barred by limitation, examined by RP or ultimately by the adjudicating authority, that claim will not entertain. But there can be numerous cases where the RP has taken a position saying that a particular claim is barred by limitation, therefore he's not collating those claims. But later on, such a party is going before the authority and filing petition before the adjudicating authority to say that, no, my claim is valid. There can be a contest on that position, but answering your question, RP is completely competent to apply Limitation Act while collating the claims.
And even during the liquidation period where he can adjudicate on the claim?
Yes.
So he should do it, or rather he should let it go and admit everything. Then practically, you see, as you said, there are thousands of claims actually, and it would be very difficult to adjudicate on every claim, whether it is within limitation or not, and seeing the date and period and all. When it would be a very difficult task for verification of the claim within 7 days. So in the practical
I think
aspect,
in maybe if there are so voluminous claims, I completely agree, it may not be possible. But in case of a large claims, I think wherever somebody see that it is out and out barred by limitation, and some fair view with the limited knowledge and the availability of time at that stage, I think that without any hesitation there, the Limitation Act can be applied.
But sir, I'm Kamal Jain. But sir, in case of RP, he has to collect the claim. But in case of liquidator, he has adjudicating power, but RP do not have adjudicating power. And to the best of my understanding, declaring a claim limitation by law is an act of adjudication. So how do you take it?
Yes. I think that's why if you see in case of a liquidation where the adjudicating powers are there, right of appeal is given there. Here, ultimately also, because these claims are to be put before the adjudicating authority in one form or the other. If, let's say that if you find that these kind of couple of cases which we have been seen in the Supreme Court, let's say that the default notice was given in case of 2011, which you can on the face of it see that this is barred by limitation. Otherwise, there is no end to these kind of claims. So I'm not saying that this is a process of adjudication. Even collation requires certain application of mind. And when you apply your mind at that stage, whatever the applicable law is part of the application of mind. And I think if I think Sandeep is there, he was mentioning he's dealing with some case where this kind of issue is going on before some tribunal.
so we have Mr. Neeraj Kumar Jajodia, I think. He is asking whether, sir, need to know whether acknowledgement from the borrower is received after 3 years of NPA. Then in that case, is Limitation Act to be extended?
No, if it is after 3 years, then becomes a dead claim. So you can't revive a dead person. You can revive a person who is about to die, which means 1 day prior to 3 years.
So anyone actually have further questions? Yes, we have one more question. Is it duty of the RP to correctly check the claim? He cannot say that he should only collate. He has already replied actually to this question. Can management make a blanket statement?
Mr. Lohia, I think Mr. Balbir Singh referred to Mr. Sandeep Bajaj. I think Mr. Bajaj can throw some light on the earlier
Sandeep,
question.
you can switch on your mic, I believe.
Can you
Yes, Sandeep ji.
Can you unmute me from another system also? I was logged in from another system. Actually, I can't unmute myself.
Sandeep, we can hear you.
Yes, please. Sorry. No, it's fine. Yes. See, what happens is, well, in Swiss Reben, Supreme Court has clarified that the power of resolution professional is only to collate the claim, and it doesn't have a adjudicating power. Like liquidators still have a quasi-judicial powers. It may still decide the claims whether to admit or not. But having said that, Supreme Court has nowhere stated that RP cannot reject the claim at all. What happens is, if the claim is filed by any of the claimant and it is not shown in your books or supported by any of the document, does it mean to say that Supreme Court has settled the law, the resolution professional can't do anything? The answer is to that is no. resolution professional is still empowered to see that whether the claim is valid, whether this claim can be admitted, and after that take a conscious call whether to admit that claim or reject that claim. So having said that, once we see that the claim is already time barred on the face of it, then resolution professional is within its right. Number one, it can reject the claim also, or number two, it can, like we were just discussing about the timeline also, that within 7 days it can't do that. Generally, the resolution professional, we have seen practically, it mentions the claim in the list of claimants and also mention that this is under scrutiny. So resolution professional, while accepting it, can put a note and keep continue with that with the claim adjudication also. Yes. And in contingent claim also, if you see that several judgment like in SR also, where resolution professional has accepted claim for ₹1 also against whenever there is a dispute regarding this. Even that has been accepted by the Supreme Court. So somehow even the Supreme Court has recognized the power of resolution professional to accept or reject the claim.
One more question we have, basically it's about the repercussion of basically the Padma Kumar judgment, wherein it said that if the balance sheet or auditor qualifies the balance sheet saying that it might not tantamount to admission or acknowledgement of the claim. So being a chartered accountant, as Balbir sir said, that we can advise our client. Now, if a particular client has been showing in his balance sheet a particular debt, you see, without any qualification. Now suddenly we advise him and say that you mention a blanket, you see, statement in the balance sheet that any amount should not mean to be an acknowledgement of that particular debt. Will this suffice? The continuous, you see, this was only happened for the first time in this year actually. So can this be done, and how will limitation will apply in such cases?
No, what happens is what I was saying is, like in a resolution professional, there are 2-3 kinds of situation which can come up before the resolution professional. One kind of situation is where we are saying the dispute is contingent and some litigation is going on. As far as those claims are concerned, again, there can be 2 things in that. One is ascertained claim and another is unascertained claim. For those, Supreme Court has upheld the right of a resolution professional to admit at ₹1. That's one part actually. Now, second part we are saying is when on the face of it claim is time barred. When we say the claim is time barred, it means there is no acknowledgement in the balance sheets. Earlier, because of the NCLT judgment, it's likely pointed out by you, a lot of CAs might have advised their clients also that one, you should put a note in the balance sheets. Number 2, if there, you can't accept it as an acknowledgement. But now with the Vishal Jaiswal judgment, law is well settled, where the balance sheets may amount to acknowledgement. At that stage, resolution professional may not be within its power to say that this claim is time barred and not to accept that claim.
Right. So one question we have from our president, Anupji, please, can you just ask directly?
No, this is not a question from me. This is a question in the mail. Somebody has given this question, and that question is very lengthy. So we cannot take these questions in this particular time. We have a limitation of time, and we have Advocate Sandeep Bajaj ji is also there. So we can probably send the questions to our learned sir over mail only.
So we'll take one last question. That is the date of default and declaration of the NPA are different dates. So whether the limitation period will start from the date of default or NPA?
See, that's an interesting question. There are a lot of judgments on this part itself where the NCLT, NCLAT and Supreme Court agreed that NPA is the date of default. Because what happens is normal scenario, even that for NPA, we also accept this fact that there should be 3 months period when the default has already occurred. But rightly or wrongly, once the NCLT has taken a position that when the account has been declared NPA, that should be considered as a date of default. That's number 1. Number 2, as sir has already pointed out in his presentation also, the date of default cannot be shifted. So date of default will always remain as an NPA, which has been accepted by all the tribunals. And from that date, everything will start.
Right. I think, let us keep all this question till the last, when our second topic comes up. Sumit ji, can you please take it over and before Sandeep ji deliberates on his topic, you can introduce him to our attendees.
Sir, Balbir Singh, sir, you would be continuing with us, no, sir?
Can I request if you can excuse me? I think I'll try and join back maybe another half an hour. I just have one more call to attend. I'll join back again.
In that case, we'll be awaiting your presence.
No, 100%. I'll be there before your session is over, and I certainly can't miss Sandeep's session. I'll join back.
And more than that, sir, we also have a memento to offer you. So
that's really kind of you, but I'll certainly join.
So, Mr. Binani, you're taking a virtual memento.
Yeah, I think it's my pleasure again to introduce one more eminent advocate from New Delhi. Advocate Sandeep Bajaj is a managing partner of PSL Chambers, and he's an LLB again from Punjab University, Chandigarh. He's a Bachelor of Management and Information Technology from Punjab University. He's also done diploma in cyber laws with the Asian School of Cyber Laws in collaboration with the Government Law College, Mumbai, and also has obtained certificate in human rights from the IGNOU Delhi University. He has been into practice as managing partner of PSL Advocates and Solicitors from 2012, and he has been practicing in New Delhi. He also had a lot of other credentials to his name, which means that he's an impaneled counsel with the Union of India in the senior panel. He's the impaneled counsel with the government of NCT of Delhi, South Delhi Municipal Corporation, Ministry of Housing and Urban Affairs, State Bank of India, Central Bank of India. Is the member of Bar Council of New Delhi with 13 years of experience, member of Delhi High Court Bar Association, member of Supreme Court Bar Association, and the member of National Company Law Tribunal, New Delhi. Recognized as a rising star in the Asia Law Business Top 50 Indian Lawyers list. He's also recognized as a recommended lawyer by Legal 500 Asia Pacific in the dispute resolution arbitration arena, and also has been featured in Who's Who, India section of Asian Legal Business Magazine 2017. Friends, I am skipping his detailed profile, but then let me tell you that in one of the recent cases in Supreme Court of India, wherein it was upheld by the Supreme Court that a promoter, a suspended director or a promoter during the liquidation process cannot put in a scheme of compromise or arrangement under Section 230 of the Companies Act. I had seen Advocate Sandeep Bajaj arguing from the promoter's side. And let me tell you that I am a witness along with maybe 200, 300 people who were there on board in the Supreme Court for a continuous period of 2 to 2.5 days when this argument was held. Sandeep has brilliantly argued the matter. He had articulated it so well that when Honorable Justice Chandrachud, he was passing the order, though it was not in favor of Sandeep's client, he really complimented Sandeep, the way he has put in this matter and the way he has assisted learned Justice Chandrachud to finally arrive at the decision. But he really complimented him very well. And I also distinctly remember that there were so many star advocates who were arguing the matters on behalf of their client. But the first name which came on Justice Chandrachud's mouth was Advocate Sandeep Bajaj and the way he brilliantly argued. So that is the introduction of Advocate Sandeep Bajaj. Sandeep would be speaking on Provident Fund, which is a key area for us as resolution professionals and liquidator, and how to handle the notices which we are continuously receiving. And I've also requested him to deal with the steps which a liquidator is required to take whenever he's trying to sell the corporate debtor as a going concern. So over to Sandeep, and Sandeep, thank you very much for accepting our request.
Thank you very much, sir. And it's a pleasure to be here actually. And it was always a pleasure to listen to Mr. Singh also. And of course, Mr. Balbir Singh most of the time in Supreme Court. So for NCLT level issues, actually I jumped in because I keep on advising the resolution professional, and Mr. Balbir Singh being the additional Solicitor General, of course, he's no more in that position where he's advising the private clients. So, okay. And I especially thanks Mr. Binani and Mr. Anoop also for having me here and for this invite. So I'll be, as Mr. Binani has pointed it out, I'll be speaking on two issues basically. First is Provident Fund issues, which we all are facing because we all are chartered accountant. We understand the kind of problem we have when we are resolution professionals or the liquidator and every day receiving the notices from the PF department asking for the dues. So it has put us in a awkward situation where if we pay the amount of Provident Fund actually nothing is left in the company and we are struggling to keep the company even a going concern. Of course, those kinds of issues are there. And second, of course, the issue is regarding the sale of corporate debtor as a going concern. So for the first issue, of course, I'll be sharing the presentation. And if I'm just being permitted, I'll just share the presentation. Okay, I'm discussing these two issues related to Provident Fund and steps for liquidation of corporate debtor as a going concern under the Insolvency and Bankruptcy Code. Firstly, we all have read about the objectives of Insolvency and Bankruptcy Code. I need not to waste time. We all have read preamble, read it several times, heard it several times. We are all bored of knowing the objectives, and everyone is talking about maximization of the value of the assets of the corporate debtor, promote entrepreneurship, availability of credit. Even at several stages, we have been appearing before NCLT. Even NCLT asked you one question: what is this about maximization of the value of the asset? We keep on talking about, even we don't understand this concept. So we all know this objective, and we all know ultimate aim also. And knowing that all are chartered accountants, I think who knows much better than me that how to maximize the value of the assets of the corporate debtor. But most important point here is this objective is regulated by other objectives of the code, which has not been spelled in so many words, but everything rotate around this also itself. That is reviving a failing company out of insolvency through a resolution plan or through liquidation by way of sale of a going concern or business as a going concern. Then provide a clean slate for the company to revive itself, free of all its past liabilities and dues, which essentially acts as the most significant catalyst, motivator for resolution applicants or prospective buyers in liquidation. And of course, most important part is secure payment of creditors. So when we say that, the first question comes in the mind that whether secure payments means, is it a kind of recovery mechanism? From the very beginning, from the first date itself till now, the law has developed and everyone has come to a consensus that insolvency code is not a recovery mechanism. But having said that, everyone is interested in receiving the money. So that is the reason in a Sheshnath judgment, which Mr. Balbir Singh has just read out also, where Justice Indira Banerjee had the occasion to deal with this and indirectly has held it, that though it may not be recovery mechanism, but at the end of the day, everyone is interested in recovery of their amount itself. So it will be totally wrong to say that the recovery is not part of the objective of the code itself. Then we all know this is the first step. The IBC talks about two things. One is insolvency and another, if we are unable to resolve the insolvency, then the liquidation. So first step is always corporate insolvency resolution process. We are trying to resolve the insolvency. We all understand the meaning of insolvency, that when the company is unable to discharge its debts, we understand that the company has entered into a phase where it has gone into insolvency and immediate steps to be taken to resolve this insolvency. If we are still unable to do that, then comes the liquidation. Then again, I just pointed it out, the main objective of the code is to revive the company. That's the reason the sale as a going concern has comes into picture now, which I'll be discussing a bit later and explain it. That was the main purpose. Again, in liquidation also, we are again trying to resolve the insolvency and protect the corporate debtor from its ultimate death. So first issue we are discussing here is the purpose of Provident Fund. Because Provident Fund issues every day we are taking up, that what is Provident Fund, what kind of issues we are facing. Provident Fund is regulated by Employees Provident Fund and Miscellaneous Provisions Act 1952, along with the scheme thereunder. The most important part of this act is it provides for a creation of a Provident Fund, pension fund and deposit linked insurance fund for employees in factory and other establishment. Now this act, of course, also provides, this is one of the social security legislation for employees, and it also provides where it is applicable, where what is the eligibility for the company. I'm not going into that aspect, that's not relevant for our purpose. Then of course it provides for 12% contribution from the employer side, employee side, then identification, and it also provides the definition of employee, but it includes the workmen also. So what are the issues which we are facing? The issue can be categorized into two categories. Number one, that the payment of the claims relating to Provident Fund arising for the period prior to insolvency commencement date, that is the date of admission when the company has gone into CIRP. And number two, once the admission has taken place, company is under CIRP, then how these claims will be dealt with by the resolution professional first, and if company goes into liquidation, how it will be dealt with by the liquidator. So to cover, let's understand first workmen and employees under the code. We have basically categorized, this is in our words, please don't take it, this has not been defined under any of the code. In nutshell, just for the purpose of understanding these issues, what we have done is all the claims of the workmen and employees has been categorized into two categories. First category is service claims, which we generally talk about salary, wages, bonus, dues, etc. And second, we have categorized to understand is welfare claims. Welfare claims means gratuity, provident fund dues, entities, and pension fund, and etc. Such claims are mostly dependent on the tenure of the employment. So there is an issue of applicability when these are applicable. If these are applicable, how it is to be dealt with. In a normal scenario, when we discussed most of the issues covered under the service claim itself, but welfare claims have taken a specific place now under the insolvency code, whether it's provided or not, but with the judicial precedent, I'll just come to that to show that. Now, even this welfare claims has its own place. So when we talk about, we generally, whether it's employee salary or whether it's the workman dues, principle remain the same except the priority, which I'll be discussing in a while. First issue comes the workman dues under the code. What is the meaning of workman dues? Now, unfortunately, it has not been explained in the code what is the workman dues. The only place where we see the kind of definition is we find it in section 53. Section 53, we all know, actually, I'll come to that also, that provides a waterfall mechanism under the insolvency and bankruptcy code, and which says that workman dues meaning is as it is defined under section 326 of the Companies Act. So 326 now, if we go there, we find that there is an inclusive definition and includes it all wages, salaries, PF, gratuity fund, and pension fund. So when we talk about workman dues, whether it's, in our words, whether it's a service claims or it's a welfare claims, everything is included within the definition of workman dues. So whenever we are dealing with workman dues, we are dealing with everything. Now, to understand this, as we have said, two stages when we are discussing it. One is claim arising after the insolvency commencement date or the liquidation, and one is prior to that. Firstly, we are taking a second issue because that's the simplest issue and it can be answered in one slide itself, where we are talking about that once the company goes into CIRP, a duty is casted upon resolution professional to keep the company as a going concern. When we come at a going concern, I'll explain that concept later, what is the meaning of going concern. But one thing is sure, that resolution professional, or for that matter, liquidator, is required to comply with all the laws and to pay the dues of all the workmen. So once insolvency commencement date kicks in, after that, it is the duty of the resolution professional to pay all the dues of the employees which are still on their roll after the commencement date. So when the services has not been discharged, when the company is going concern, and when we are keeping the employees on our rolls and taking their services, that it is the duty of resolution professional to pay all employment dues, whether that's a pension fund or gratuity or provident fund or salaries, everything inclusive of this. But the same is not true when the dues arising for a period prior to insolvency commencement date. So the most relevant part is the insolvency commencement date, as we all understand the date of admission when the company has gone into CIRP. For this, actually, the first question comes in how to deal with all these claims when we are receiving it. And employees, or for that matter, fund. Now, that's again a question actually we all must be facing, that who needs to file this claim? Because we all understand whenever there are due pending, this has to be, as specifically welfare dues, pension fund or provident fund or gratuity. Gratuity may be directly payable, but provident fund, it has to be credited to the account of the fund. It is not directly paid to the employees. Then who will file the claim? That's another question actually altogether, where we are every day facing this kind of problem and seeing that if provident fund has not been paid to the fund, who is the person who will file the claim? But let's skip that part for the time being. Coming to the issue, that how the code deals with all these issues and claims which arises prior to the period of insolvency commencement date. The answer lies in section 30 subsection 2 during a period of CIRP. Why section 30 is because we are assuming a situation that during the period of CIRP, we have received the resolution plan, because there is only two possibility during CIRP. One, we are receiving resolution plan. Another possibility is there is no resolution plan, or it has failed and company has entered into the liquidation. So we are talking about the first stage where we are assuming that the resolution plan has come and it is being approved. At that stage, what is the protection given for these claims? So for that matter, section 30 of the code provides a specific protection to these employees. And it says, as employees and workmen are operational creditors, section 30 subsection 2b mandates that a resolution plan is required to provide payment of dues to operational creditors, which they would get at the time of liquidation of the CD. Relevant part of section 30 we have just quoted provides for payment of debts or operational creditor in such manner as may be specified by the board, which shall not be less than the amounts to be paid to such creditors in the event of a liquidation of a corporate debtor under section 53, or the amount that would have been paid to such creditor if the amount to be distributed under the resolution plan has been distributed in accordance with the order of priority in subsection 1 of section 53, whichever is higher. So the protection here given is two things. Number one, if the amount which is mentioned in the resolution plan is distributed as per the waterfall mechanism provided under section 53, what amount the operational creditor would be getting, or in general scenario where other amount, suppose liquidation value or fair market value, assuming that that is being distributed under the waterfall mechanism, how much amount the operational creditor is getting, that is the minimum amount which has to be provided under the resolution plan to comply with the mandate of section 30 subsection 2. Now employees being the operational creditor, this is the protection given to them. Because whenever you are assessing a resolution plan, when you receive the resolution plan, you see that how much amount is being paid to the employees. Now for that, we need to go to section 53. In case of waterfall mechanism, how much amount employee will be getting. To understand that whether the resolution plan is providing minimum that amount or not. So for that, if we see section 53, it provides the priority to workmen dues at par with secured creditor, and next priority is given to employees dues. So 53 provides the priority, and first priority is given to insolvency resolution process cost and liquidation cost. Number 2, it provides the priority to workmen dues and dues of the secured creditor who have relinquished the security under 52. So these are on the same pedestal, and then the priority has been given to employees. So once we have received the resolution plan, we are seeing it here that how much amount is going to the employees under section 53. Minimum amount they are getting there should be there in the resolution plan. Now the question arises when we talk about the minimum amount, whether it includes the provident fund dues or not, because it generally talks about the workman due. As we have just pointed it out, definition of workman dues is an inclusive definition, includes everything. So what we need to see is under 53, during the period of CIRP, whether employees is getting the amount which is sufficient to cover their dues for 24 months or not, proceeding for 24 months. That's the maximum which they'll be getting if the amount is enough to meet all the debts. That's number one. If the amount is not sufficient for that, then how much amount is employees getting? I'll come to rainbow judgment and other judgment. I'll explain it how the court has interpreted it. But basically, if we see only the code, this is the only requirement at the stage of 53 to understand that what we need to see is 53.2b, 53.2, seeing that how much amount workmen will be getting. So we have to see during CIRP, the resolution plan can provide for treatment of all workmen and dues of employees and statutory dues as per section 30 subsection 2 read with section 53. In RPF versus Vandana Garg, the NCLT had an occasion to deal with this, and it says the exclusion of welfare dues from the liquidation estate is only applicable during liquidation. I'll come to this part actually, because why these issues are arising because of section 36 subsection 4, to which I'll come, because these dues has been excluded from the purview of the liquidation estate. But NCLT in earlier judgment in Vandana Garg specifically said that this is there when the liquidation is going on. During the period CIRP, we should not see this. So during CIRP, there is no protection afforded to welfare dues. These all are covered under the workman dues under section 53 itself. If amount, they are getting only 10% of their total dues, then this is what ought to be provided under the resolution plan as per the bare perusal of the provisions of the code itself. In another judgment, in Rainbow, in a recent judgment now, interestingly, NCLT interpreted again, where it says, while considering the resolution plan, the successful RA is supposed to pay the total provident fund dues. Now, having said that, when they are saying the total, which of course has been upheld by the Supreme Court also, the only reasoning given by the NCLT is that these dues do not form part of the assets of the corporate debtor. If these are not the assets of the corporate debtor, then these dues are to be paid upfront itself. But if we, of course, I have a personal reservation about this, because if we draw this analogy, then there are several issues come up, like the issue regarding the tax payment also, GST payment also, indirect tax which has been collected by the corporate debtor. That will not be the amount of the corporate debtor itself. That's an asset which they are holding interest, that is also to be paid in priority. But rightly or wrongly, NCLT has done that, and Supreme Court, of course, in this judgment has been upheld, but there no reasoning has been given. It was dismissed on the first day itself. So this issue will be considered on time. But at this present situation is, whenever any resolution plan is coming, what we need to see is, in addition to section 30, subsection 2, and read with section 53, what needs to be seen is whether the dues of employees are paid in full or not. So that's the problem all RP are facing today. But in view of this judgment which has been upheld, the present situation remains is the complete dues are to be payable. Then what has been held in this is NCLT declared that no provision of EPF Act conflict with any of the provision of the code. NCLT therefore directed the resolution professional to release the full amount of the provident fund, including the interest thereon, in terms of provision of EPF and Act. Because another interesting point is, when we talk about the provident fund dues, whether it's only the principal amount or the amount of interest as well as penalty which takes the priority. But NCLT has held even those dues are to be paid. Though, of course, there is no specific finding why these two dues are to be paid. The only reasoning again has been provided is no conflict between the two codes, which I'll just come to that also. I'll provide another point of view, which may be considered on a relevant time, whether may be upheld or rejected. But yes, there are certain other points of view which can be considered, and it may be considered on a relevant stage. So now, let's take after this Rainbow judgment, of course, situation is there in CIRP. Now I'm going to the next stage itself. Once the CIRP is over, there is no resolution plan which has been approved. So payment has not been made to all the creditors, including the employees, and company goes into liquidation. So once the company goes into liquidation, everything revolves around section 53 waterfall mechanism, where it provides that when the payment is to be made to which of the creditor and how much and at what stage. It provides the priority to certain claim while ignoring the priority to other claim. Of course, it is in line with the earlier Companies Act itself, where 326 of the Companies Act 2013 and 530 of Companies Act 1956 provided the priority. It's in line with those only. It has been provided certain priority, but it has changed the priority now. So, but everything revolves. Now, when we are talking about the workman due under 53, interestingly, those workman dues talks about only the service dues as per the judgments of the court. Because as far as provident fund, pension fund, and gratuity is concerned, that has specifically been excluded under section 36, subsection 4. What happens is, when the initially first draft of the code came, there was no such provision as Section 36 providing for a specific exclusion of these dues. So the matter was considered by the Joint Parliamentary Committee, and they came to observe that PF dues, pension fund, and gratuity funds provide the social safety net to the workmen and employees, and hence need to be secured in the event of a liquidation of a company or bankruptcy of a partnership firm. Therefore, the committee recommended that all the sum due to workmen or employee from the PF pension gratuity should not be included in the liquidation estate, and it should be kept outside. This was done after inserting Section 36, where it provides, unlike CIRP, the welfare dues are taken away from the ambit of Section 53, which I just said that of course, NCLT has interpreted during the period of CIRP also, which is contrary to the earlier judgment where they say it should be applicable only in liquidation. But now they have interpreted the same thing in CIRP also, where they are saying in CIRP as well as liquidation, what we need to see is these are not the assets of the corporate debtor. So to understand this clearly, now see the exact wording of Section 36, subsection 4. It talks about the following shall not be included in the liquidation estate asset and shall not be used for recovery in the liquidation. Asset owned by third party, which are in possession of the corporate debtor, including, now the wording is most relevant, it talks about all sums due to any workman or employee from the provident fund, the pension fund, and the gratuity fund. So what has been excluded from the ambit of liquidation estate is sum due to employee or workman from provident fund, pension fund, and gratuity fund. Interestingly, it doesn't talk about the dues from CD or corporate debtor to fund. It excludes the amount due to employees from provident fund or pension fund or gratuity fund. So what happens, I'll just explain that the provident fund provides that all the companies needs to maintain the provident fund. What the corporate debtor is liable to contribute its amount in the fund itself. Then the fund releases this pension to the employees. Provident fund are not directly paid by the corporate debtor. So there are two steps in this. First step is from CD to fund, and the second is CD to employees. So bare reading of Section 36, subsection 4 excludes from the purview of liquidation estate is the second leg, not the first. Because when the amount is lying with the corporate debtor, according to my understanding, it's really difficult at this stage to say that this amount belongs to whom. Because I compare it with the indirect taxes also, which has been collected by the corporate debtor, maybe TDS issue also, which have been deducted by the corporate debtor but has not been paid. So if we consider this, that the asset belong to corporate debtor or do not belong to corporate debtor, then do not belong to corporate debtor several of its aspects, which can't be differentiated. So that's why wording of Section 36, subsection 4 was very clear. But when the interpretation came, then this matter was earlier considered by NCLT in Precision Fastener case, where the Provident Fund came and in fact attached the assets. So matter was challenged before the NCLT Mumbai. Mr. B.S.Y. Prakash and Mr. Doraiswamy considered this issue in detail, threadbare. They come to a conclusion that this is a social welfare legislation. They observe that dues of PF pension have to be deemed to be an asset of the workmen or employees, irrespective of whatever they have been maintaining in a separate account or not by the company under liquidation, whether they are maintaining the fund or not. It is further observed that by including all the sum due in any workman or employee from the Provident Fund, Pension Fund, and Gratuity Fund under Section 36, subsection 4A, an overarching interest and the title has been created in favor of a workman in respect of PF. It further held that all the creditor over the assets of the company is a property right, whereas workman dues are interwoven with the right to life, because these amounts are the saving made by the workmen out of their hard-earned money for life after retirement, and linking such sum on par with the debt of the creditor is nothing but diluting the most valuable and inalienable right of a person. So NCLT has taken to that level and says that it is attached to right to life of the workman or the employee, and they should be paid in priority to anything else. Interpreting Section 36 and subsection 4, meaning that all dues welfare dues when we are talking about. As far as the service dues are concerned, that's taken care on 53. They are not talking about the service dues here. They are talking about the welfare dues. Then another judgment of NCLT, Moserbeer. There are several judgments of Moserbeer. I'll call it a Moserbeer 1, where appellate tribunal has an occasion to consider this. Again, the appellate tribunal held that all sums due to any workman or employee from the PF, the pension fund, and the gratuity fund do not form part of the liquidation estate. There is a difference between the distribution of assets and preferences priority of workmen's dues as mentioned under section 53 1B and section 326. While applying section 53, section 326 is relevant for the limited purpose of understanding workman due, which can be more than PF, pension, and gratuity, and protected under 36(4). On the other hand, workman's dues as mentioned in so-and-so is not confined to a period like 24 months preceding the liquidation commencement date, and therefore the appellant for the purpose of determining the workman's dues as mentioned in section 53 1B cannot derive any advantage of explanation 4 of section 326 of the Companies Act, where they provide the definition of workman dues, what should be included, because the argument was raised, if the definition of workman dues include everything, then the protection is already given in 53. You can't interpret the another protection in section 36 because it is already covered. And it can't be envisaged that the court is providing the protection at 2 stages for the same thing. But appellate tribunal held that, sorry, in 53, it is not limited to only what we are calling here is as a welfare claims. It talks about more than that, like a service dues, like salary, wages, and bonuses, etc., everything. But it doesn't talk about these 3 funds. So therefore, it says once the liquidation estate of the CD read by so-and-so do not include all sums done, sum due any workman and employee from the provident fund, the pension fund, the gratuity fund, for the purpose of distribution of asset under section 53, the PF, the pension fund, and the gratuity fund cannot be included. It has to be paid. It has to be paid in priority to other, number 1. Number 2, it will never form part of the liquidation estate. So if the liquidator is taking over the corporate debtor, what it needs to do is, firstly, it has to pay all the dues of the workmen, which are mentioned in 36(4). If it doesn't have, let's take an example that the corporate debtor doesn't have that much of fund, then liquidator needs to sell the assets also. And after selling the asset, the amount which comes, now that's another interesting point. When we are discussing this, we all know when liquidator liquidates the things, it firstly makes the liquidation estate, then sell the assets and bring the money in that liquidation estate and then distribute it. So a question may arise that if there is no fund today, which can be paid to the fund, and liquidation estate is empty, so once the liquidator is selling and what is bringing, that should form part of the liquidation estate, and it can't be distributed to the funds. But the answer to this is again no. It has again been interpreted by adjudicating authority Chennai bench, where it says that liquidator counsel himself has stated that the payment to be made to EPF authority cannot be treated as part of the liquidation estate for maximization of the asset of the company, since it is not feasible to separately sell off the asset proportionate to the claim of the applicant. Recovery officer, the liquidator can sell the assets of a CD as stated under Insolvency and Bankruptcy Code and first pay off the dues payable to the applicant before distributing the assets as stated under section 52 and 53 of the Insolvency and Bankruptcy Code. Now it comes with several challenges. First, of course, it has, sorry, I'm doing a critical analysis of all the judgments itself because we all need to understand this concept. Because it says, before distributing the assets as stated in section 52. Section 52, if we all understand in right perspective, 52 gives the right to the secured financial creditor to take away the assets first, not to relinquish it, to sell it by the liquidator and to make part of the liquidation estate and then distribute under 53. So when we are talking about this, the first question which arises is, the liquidator, how would he sell these assets which has not been relinquished by the secured creditor itself? Because if a secured creditor exercises the option under 52, take away the asset, then liquidator will not have anything to sell and then to contribute that asset. But this has not been tested by the appellate tribunal as of now. This is by the adjudicating authority Chennai, which has held that before doing anything, you pay off those dues, even if you need to sell the assets. How will you sell the assets? Taking away from the rights of the secured creditors? That will have to be seen actually. Then, of course, Moserbeer, another Moserbeer 2, where again the adjudicating authority held if there is any deficiency to the PF pension and gratuity, then the liquidator shall ensure that the fund is made available in the aforesaid accounts, even if their employer had not diverted the requisite amount. So another is Autonix, another judgment of Moserbeer 3, where again a similar line, adjudicating authority held, we would like to fall in line with the ratio laid down by the Honorable Principal Bench, wherein it is clearly held that the shortfall in gratuity has to be made over by the resolution professional and payments of the dues has to be paid outside the waterfall mechanism. The said finding is also upheld by Honorable NCLAT. Therefore, we hereby allow this application. It is directed that the RP to release the dues of the ex-employees and deposit the PF with EPFO and release gratuity dues with the forthwith. So, consistent law on this point is whether companies under CIRP or companies under liquidation, the views taken by the adjudicating authority, appellate tribunal, and upheld by the Supreme Court, though the question of law has not been tested, is to make these payments upfront. If you have fund, pay this amount. If you don't have this fund, arrange this fund. In CIRP, ask the resolution applicant first to make provision of this fund to be paid in full. If the company is in liquidation, sell the asset, firstly get this amount, pay off the dues, and only then you can proceed with your other duties. And of course, in VCon integrated solution, the adjudicating authority again held that the contribution, interest, and damages payable by the corporate debtor under the employees' provident fund and miscellaneous provision are statutory dues and not claims which can be submitted to the liquidator. So again, they are saying it's not only principal amount. They have gone to an extent that even if the amount is not paid on time by the erstwhile management, and interest and penalty has been imposed by the authority, then it becomes the duty of the liquidator or the RP to pay the entire dues. So the resolution professional during CIRP has to make sure that the resolution plan has paid in full the entire amount of the workman dues. When I say workman dues, means these three funds mainly. Other workman dues, now interesting, that's an interesting part is when we are categorizing it in another form. Service dues, it's possible they may say we are paying 90% of the salaries or 80% of the salaries because they are the operational creditor, they have the operational debt. There are several NCLT judgments which has not gone into this issue and they have approved the resolution plan. But when the question comes regarding these three funds, Provident Fund, Pension Fund, and the Gratuity Fund, the law is consistent, holding that you pay off the entire amount. There cannot be any discount. There cannot be any haircut here. You need to pay the entire amount. Then in Rainbow also, the similar provision has been held where there was a question arises that only a part of the amount has been allowed by the resolution professional. But after hearing, the NCLT declared that the no provision of EPF conflict with the provision of the INB code. In terms of section 3643, the PF and the gratuity fund are not the assets of the CD. There being specific provision, the application of section 238 of the code does not arise. 238 provides the superseding right to IBC code on other provisions. It says that the IBC will prevail over all other acts when the company goes into insolvency. So it says that at 238 we apply when there is a conflict or contradiction between the two provisions. But court has said, as far as EPF Act is concerned, there is no conflict between the two provisions because EPF Act also provides the charge over the assets of the corporate debtor for any dues which are to be paid to the funds, number one. Number two, EPF Act also provides the priority which has to be read with Section 36. And if we read all the sections together, there is no conflict. If there is no conflict, a pay of the entire amount. Sorry. So, as I have already pointed out, Vandana Garg judgment, they have provided that this provision applicable only during the period of liquidation. But in Rainbow, they have taken a contrary view, which of course will be considered by at an appropriate stage itself. Now, when we say that, what is the problem what the RP or liquidator can have to make this payment? Because I'm telling you here the practical experience when we are advising resolution professional and the liquidator each day, this kind of question comes where it says, if we pay this amount upfront, that what will be left? So it has been seen that amount due towards these welfare claims are excessive to such an extent that the entire amount realized by the liquidator goes into the settling the dues of the funds, leaving nothing in the liquidation estate. And when we talk about the dues towards welfare claims, we are talking here about the interest and penalty, which is huge. And if we add that to the principal amount, the amount becomes so much that the liquidation estate is left with nothing. So this issue needs to be considered at relevant stage. And number two is again relevant issue, as CIRP as well as liquidation cost is met from the liquidation estate. There may be a cases where no fund is available for meeting such cost after settling the dues of these funds. So if we understand these concepts, saying that this is not the asset of the corporate debtor, but let's assume the assets of the corporate debtor are not enough to meet this liability. There might be several reasons actually when the payment has been diverted or siphoned, or in any case company is not in a position to pay off the debts. If we pay off the debts and nothing remains in the asset, who will have a priority? Now once the court says 36.4 is applicable, 36.4. So if we pay this amount upfront, what we need to see is how to meet the CIRP cost and liquidation cost also, because even those claims cannot have the priority, because that will fall under the mechanism of 53, whereas these claims are not, that does not even fall under the mechanism of 53. These are kept outside of 53 itself, paid in priority to anything else, paid in priority to all the dues of the under the IBC. So these are the issues actually which we are saying we have raised in several forums. Of course, has not been considered as of now. Section 36.4, which I just pointed, excludes only such welfare dues which are due from the fund, the wording which I read, and not some due from the corporate debtor to the fund. This issue will be decided at relevant time. Another issue is when the court in Rainbow says there is no conflict between the two provisions, court has relied upon two sections of EPF Act. One is Section 10 and another is Section 11. I'll just read the wording. Section 10 of EPF Act provides for the protection of the fund from attachment, which if read with Section 36.4 explains that only the welfare dues which are due from the funds are excluded. The wording is very relevant here because it talks about the dues from the fund in Section 10 and not from the corporate debtor to the fund. Section 11 talks about the dues from the corporate debtor to the fund. But again, Section 11, subsection 2, what provides is creation of a charge and payment in priority to all other debts, which has already been provided under 53. So if we see wording of Section 10, subsection 1, protection against attachment, it says the amount standing to the credit of any member in the fund shall not in any way be capable of being assigned or charged and shall not be liable to attachment under any decree or order of any court in respect of any debt or liability incurred by the member. And neither the official assignee, though of course it has not been amended, other acts has been amended providing the Insolvency and Bankruptcy Code, but let's assume a situation that this act even applies to this provision also, though it should have been amended, but it's not amended. So even it talks about under the Presidency Towns Insolvency Act or Provincial Insolvency Act shall be entitled to have any claim or any such amount. So what it provides is the protection from the attachment by the liquidator that is in liquidation estate itself. It cannot attach the asset and make part of the liquidation estate, but what amount? funds, 3 funds which has been created where the amount has already been credited. That's why it says the amount standing to the credit of any member in the fund, not in the corporate data. Similarly, section 11.2. Section 11 talks about priority of payment of contribution over other debts. It says it shall have a priority, and section 11.2 further provides that without prejudice to 1, if any amount is due from an employer, or the employee's contribution, the amount so due shall be deemed to be the first charge on the assets of the establishment. That's number 1, and shall, notwithstanding anything contained any of the for the time being forth, be paid in priority to all other debts. So when we say paid in priority to all other debts, then you'll have to go back to section 53 and interpret it. Even there also workman dues has been provided in priority to all other debts, pari materia with secured creditor debt. So there is no other difference, there is no other thing which has been provided under the code. This can be read with section 53, but according to, of course, our view, which of course will be tested on time, it cannot be read with section 36, subsection 4. So as far as this is provident fund dues are concerned, these have been sufficient. We have mentioned about the present law, how it has been interpreted, whether during the CRP, whether during the liquidation. As of law, the law stands is for all of us, we need to pay the dues. And of these 3 funds specifically, as far as other dues are concerned, there may be a haircut, but these dues are to be paid in full during CIRP also and during liquidation also. So we are just moving to now the next topic of the day, that is concept of going concern under the code. See, now, once the company goes into liquidation, when CIRP fails, then there are certain duties provided to the liquidator. And in section 35, the foremost duty of the liquidator is, the most important one is, he is required to sell the immovable and movable property and actionable claims of the corporate debtor in liquidation by public auction or private contract, with power to transfer such property to any person or body corporate, or to sell the same in parcels in such manner as may be specified. In Regulation 32, when it was originally incorporated, there was 4 methods where the liquidator could have fulfilled these duties. 4 modes were provided, which were: the liquidator could have sold the asset on a standalone basis. He could have sold the asset on slump sale. He could have sold the assets collectively or in parcels. There was no mechanism or provision providing the liquidator to sell the corporate debtor as a going concern. Earlier, section 457 of the Companies Act and 282 of the Companies Act 2013 also, it specifically have the provision to sell the corporate debtor as a going concern, but they were never enforced. Therefore, even neither the code had this section, even under the Companies Act where such provisions are provided, those were not enforced. So a question came before the NCLT in, of course, Gujarat NRE judgment itself, which you all must be aware of. That's the landmark judgment in itself, where the question arose before learned adjudicating authority Kolkata bench, that whether a direction can be passed to the liquidator to sell the corporate debtor as a going concern without there being any provision under the code or under the liquidation regulations. After considering all the aspects, where NCLT has observed that there are 1178 employees and workmen on its roll, and if the order of liquidation is passed under section 33, it would lead to discharge of the employees and workmen except when the business of CD is continuing as a going concern. Therefore, after observing it, the learned adjudicating authority in its landmark judgment said, the workmen of the corporate debtor shall be stripped of their livelihood unless the corporate debtor continue to remain as a going concern even subsequent to the order of liquidation, and further directed the liquidator to sell the company as a going concern. What the adjudicating authority considered is, even earlier also, when in the Companies Act, there was no such provision. There have been several judgments of the Supreme Court where Supreme Court has directed and upheld the sale of the corporate debtor as a going concern. And it says, yes, you can proceed and you can sell it. And of course, Mr. Sumit Binani is the liquidator in that and still trying to sell the company. I'll come to that also. What is the recent position in this? Now, the first question comes is, prior to that, in another judgment of Supreme Court also in 2020 held that the liquidation of the corporate debtor should be a matter of last resort. So prior to that, even all the courts have considered this and decided that yes, the first priority should be to sell the corporate debtor as a going concern. That should be the first criteria, so that revive the company, as we just told it. That is one of the main objectives. Have not been provided in so many words, but everything revolves around this. Even under liquidation, when the CIRP has failed, it doesn't mean to liquidate the assets of the company. It still says that if there is any chance to revive the company, revive the company. Therefore, after the judgment of Gujarat NRE, there was an amendment which was made to Regulation 32, providing another mode of sale of assets, where it is provided the liquidator to sell the corporate debtor as a going concern. Regulation 32 was substituted again, in addition to the above, to introduce the concept of sale of business of a corporate debtor as a going concern. So two modes were prescribed, and what Regulation 32 now reads as is providing 6 modes of sale of the assets of the corporate debtor. 4 modes, which I just read earlier, and the 2 additional modes were provided, and there's a difference between the two, kindly understand. It says the corporate debtor as a going concern and the business of the corporate debtor as a going concern. I'll come to this, the difference between the two, and what is the meaning of corporate debtor as a going concern and business of the corporate debtor as a going concern. Now, the first question which comes to the mind whenever someone is reading it, what is the meaning of going concern? Again, it has not been provided under the code, the meaning of going concern. Definition has not been provided. But having said that, at 3 different places where going concern concept was discussed and detailed. First is Insolvency Law Committee report, where it says the phrase as going concern imply that the corporate debtor would be functional as it would have been prior to initiation of CIRP, other than the restrictions put up by the code. Then IBBI also discussed and said in discussion paper, going concern means all assets, tangible or intangible, and resources needs to continue to operate independently. A business activity, which may be whole or a part of business of the corporate debtor without values being assigned to the individual asset or resource. Then Indian accounting standard, which you all must be aware of much better than me. It defines going concern as the enterprise is normally viewed as a going concern, and that is as continuing in operation for the foreseeable future. It is assumed that the enterprises has neither the intention nor the necessity of liquidation or of curtailing materially the scale of operations. Now, why going concern? Because it has its own benefits. We have just carved out a few benefits which have been considered by the tribunals and upheld that this is the reason why they want to maintain the corporate debtor as a going concern. Of course, the foremost reason is it preserves the employment. It protects the viable companies to go into complete liquidation, to shut down, to go into its ultimate death. Then, of course, it provides in the interest of all the stakeholders, including the trade creditors who are dependent on the enterprise for their survival, reduction in return for secured and unsecured creditor and other stakeholders, loss of revenue to the government dues, everything is continuously payable. So because of all these benefits, even the tribunals has considered this, and in a top first judgment, which is a March 2021 judgment, where they have again considered and upheld the sale of this company as a going concern. The bench even feel that these are the benefits which will arrive from the sale of the corporate as a going concern, that the entity corporate debtor itself gets transferred. The equity shareholding gets transferred or extinguished and new shares are issued, the purchaser is expected to carry on the business of the corporate debtor after the sale of the assets is confirmed. The existing employees will have a chance to continue in their employment. In the discussion paper, even IBBI discusses, and it tries to provide a manner in which the sale of the corporate debtor as a going concern shall be proceeded. It says in the form of going concern sale, the CD will not be dissolved. It will form part of the liquidation estate. It will be transferred along with the business assets and liabilities, including all contracts, licenses, concessions, agreements, benefits, privileges, rights, or interest of the acquirer. The consideration received from the sale will be split into share capital and liability based on the capital structure that the acquirer decides. There will be an issuance of shares by the CD being sold to the extent of shares capital. The existing shares of the CD will not be transferred and shall be extinguished. The existing shareholders will become claimant from the liquidation proceeds under section 53 of the code. The unique feature of going concern is that since the business of CD can be transferred as a going concern, there exists a possibility of transfer of a whole lot of intangible forming part of the business, contract, leases, licenses, and other things. And in other words, it can be said that the third party acquirer takes the company as is various basis and continue to run the company as a going concern. In another discussion paper in April 2019, they again considered this issue and again held that, of course, the benefits of going concern, similarly providing, of course, it will keep the company as a going concern, which is the interest of all the stakeholders. Now, interesting point is in all this discussion paper, another question comes is whenever the liquidator is selling the company as a going concern, what are the assets and liabilities he's selling? Does it mean that going concern means everything put together, he's selling it to the buyer? Or there is a possibility that there are few units within the same corporate debtor which are not working, which are dead, which are not the known core assets of the company. Like we can take an example of a resolution plan of a jet airways. It talks about the core asset and non-core asset. Core asset where the main business is comprising and there may be in addition to that non-core asset. In those scenarios, the liquidator is not bound to sell everything in one go and saying that in going concern, I don't have any choice. The liquidator has specific power and discretion to package the assets and liability. Package the assets and liability in such a manner that where it's still selling it, core assets are still being protected, while at the same time, non-core assets are being sold in parcels or in some other way. Because it's the liquidator who needs to decide at this stage. He has been given a discretion, even it has been considered by IBBI. And in discussion paper, it has specifically been held. In case the GCS is undertaken at the choice of COC, the COC including the secured financial creditor shall indicate composition of assets and liability to be sold as a going concern. In any other case, liquidator may have flexibility to package the assets and liabilities as per market practice and offer every option under regulation 32 of the regulation simultaneously. So even when the sale of the corporate debtor is being held as a going concern, it doesn't mean you are selling all the assets together. You may still carve out certain assets, you may still carve out certain liability, even put the liability on the acquirer. So that discretion is given. Even IBBI has accepted that discretion in discussion paper. Now, when we say the going concern, of course, we have just read Regulation 32 provides two modes. 32A is sale of a corporate debtor as a going concern, and F is sale of the business of the corporate debtor. The difference between the two is in a corporate debtor as a going concern, the corporate debtor itself will be retained. Because what we see under the IBC code is if we are selling anything else but the corporate debtor, then section 54 it's mandatory for the liquidator to file an application for dissolving the corporate debtor. But when we are selling the corporate debtor as a going concern, entire company is being transferred to the other person. There is no need to file section 54. Company as it is going with all its rights, with all its liabilities, whatever has been packaged in that, and it can continue with that. But when we talk about the business of the corporate debtor, again, in business also, there is possibility for the liquidator to package different assets. But company remains outside of the purview of that. And then after the sale of the business, liquidator may file an application seeking dissolution of that company. Then in addition to once these two modes have been provided, the IBBI has amended the liquidation regulation, providing 39C in CIRP regulations, where it says that when you are at the stage of COC passing a resolution to send the company into liquidation, at that time it will also assess it whether the corporate debtor ought to be sold as a going concern or not. And in addition to that, regulation 32A has been added in the liquidation regulation. And if we see 39C, it simply says the committee may recommend that the liquidator may first explore the sale of the corporate debtor as a going concern. When we say is this, we may explore, and 6 modes are provided. I'm again saying it has been left to the discretion of the liquidator. It's not binding on the liquidator to sell the corporate debtor as a going concern. He still has a discretion assessing the situation after that. But prior to that also, at a stage of CIRP, when the COC is passing a resolution, it has to assess the situation. Again, where the 39C2 says, where the committee recommends sale as a going concern, it shall identify and group the assets and liabilities. Again, package the assets and liabilities. Then 32A is provided, where it says where the COC has recommended the sale under ENF, or where the liquidator is of the opinion that the sale under clause ENF. So both have been given the option. If the committee of creditor has not considered, the liquidator has been given discretion, and both has been found place in regulation 32A, where a decision is taken that we will try to sell the asset as a going concern, of course, keeping in mind the main objective of the code for maximization value of the assets. It says he shall endeavor to first sell under the said clauses. And if he is doing that, then further protection is provided that this period will not be counted. Where the committee of creditor has not identified the asset, he shall identify. If the liquidator is unable to sell it within 90 days from the liquidation commencement, he shall proceed to sell the assets and so on. So 90 days period is provided. And of course, it has been also added in the meanwhile, there were 2 judgments of which was the judgment? I'll just come to that. Where the NCLT has passed 2 judgment, Shivram judgment, where it says that firstly you try to sell the corporate debtor under 230 of the Companies Act. Specific rights have been given that the liquidator, whenever is liquidating the assets and coming to these modes as provided under regulation 32, then liquidator may firstly try to ask for the members or the creditors to propose a scheme under 230, and 90 days time period has been given. So in addition to that, liquidation regulation have been amended. That provision is also provided. That's also the liquidation process, and where the corporate debtor goes as a going concern, but we are not touching it here. We are touching only the mode of sale under regulation 32, which provides the 6 modes. And in that, E and F provides the corporate debtor and the business as a going concern, and within 90 days, liquidator is required to try. But 90 days, again, when we mention about the 90 days, there is no sacrosanct, it's not sacrosanct. It can still be extended, or the permission can be sought from the adjudicating authority if there is a possibility to sell it to maximize the assets of the corporate debtor. Then what are the modes of sale as provided under 32? Basically, broadly, we can divide it into 2 parts. One is, of course, auction, and second is the private sale. For that, regulation 33 provides that the liquidator shall ordinarily sell the assets of the corporate debtor through an auction in the manner specified in Schedule 1. So Schedule 1 to liquidation regulation provides the complete modes. I'll just come to that. It says the liquidator may sell the assets of a corporate debtor by means of a private sale also in the manner specified in Schedule 1 when the asset is perishable, the asset is likely to deteriorate in value significantly if not sold immediately, the asset is sold at a price higher than the reserve price of a failed auction, the prior permission of the adjudicating has been obtained for such sale. So there's in a private sale, otherwise you don't need any permission. You may still go ahead if it falls under any of the clauses which has been provided under regulation 33(2), but in few cases you require a permission which has been provided in D. When the asset is being sold to a related party of the corporate debtor, or his related party of the liquidator, or any professional appointed by him. So if I am an advocate, I have been appointed by the liquidator and I am purchasing the assets, it can't be sold to me. They'll have to seek permission from the adjudicating authority. Similar is the concept with the related party of the liquidator or related party of the corporate debtor. In those scenarios, In a private sale, it needs permission. Otherwise, there is no such need for any permission. It can still go ahead with that if it falls under any of the clauses. The liquidator shall not proceed with the sale of an asset if he has reason to believe that there is a collusion between the buyer or the CD related party and buyer, the creditor and buyer, and shall submit a report to the adjudicating authority in this regard, seeking appropriate order against the colluding parties. Then Schedule 1 provides the complete mechanism where it says the liquidator shall prepare a market strategy, prepare terms and conditions of the sale, make a public announcement, provide assistance to interested buyer, sell assets through the electronic auction, physical auction. Auction should be transparent. Highest bidder shall be invited to make payment within 90 days. Sale stands completed on payment of full amount. So 90 days time period is a maximum time period which has been provided under the Schedule 1, in which once the sale is done, when the auction is held, the entire amount needs to come. So there has been a several scenario during this last 1 year of pandemic also, where we have been seeing that the buyer was not in a position to make the payment and has been seeking extension from the liquidator. But we, of course, have already advised also that it's not possible for the liquidator, because wording of Schedule 1 is very clear, where it says it shall complete it. The money should come within 90 days itself, otherwise he shall forfeit the amount and the sale will be set aside. And if any extension is required, then any intended purchaser needs to go to adjudicating authority and seek permission. Now, what should be the consideration and transfer of corporate debtor to the successful purchaser? Consideration will be the price at which auction sale of corporate debtor is successful, which will depend on the reserve price determined in terms of Regulation 35 of the liquidation regulations, which is a realizable value. The consideration paid shall be for part of the liquidation estate, and the creditor shall be paid in the order of priority under Section 53. So whatever the amount comes, that will be divided under 53. The corporate debtor can be transferred by issuance of shares by the legal entity. This cannot be a case of transfer of existing shares, as existing shareholder become claimant in the process of liquidation, though they are the last in waterfall mechanism. On sale, the assets where security interest is relinquished pass on to the successful purchaser. It may be prudent to approach the learned adjudicating authority for an order pertaining to sanction of sale as a going concern, the issue of shares, settlement of all existing claims, and liability pertaining to the period up to the completion of liquidation, as we have seen in Topworth case itself. Now, when we say that going concern, like I just discussed, whether it's mandatory for the liquidator to go for a going concern, the answer to that is no. It has already been discussed in a very recent order, which has been passed on 3rd of May 2021. Of course, in the case of Mr. Binani only, where learned adjudicating authority, Calcutta, had an occasion to deal with this. And what the adjudicating authority held is, at some point of time, hard decisions are called for in life of a company, and these have to be taken. Unviable units will have to be closed down. The actions will have to be measured up against the objective of the code, one of which is free up resources of unviable company by permitting an easy exit. It cannot be misconstrued to keep unviable units afloat by some sleight of hand under the guise of keeping it as a going concern, thereby defeating the key objective of the code. So even the adjudicating authority as well as IBBI discusses, this is a discretion which has been conferred upon the liquidator to take a call whether to sell the company as a going concern if it's beneficial to maximize the value of the assets of the corporate debtor. Now, in a recent judgment of MADC, the learned adjudicating authority Mumbai, in one of our cases, actually special given a note of caution to the liquidator, where it says liquidator is directed to strictly follow the regulation before making the offer for selling the unit as a going concern basis. It should be ensured that none of the creditor opted for selling for the secured asset. So in MADC judgment, learned adjudicating authority had occasion to deal with this. And it specifically says, now while you are selling the corporate debtor as a going concern, what needs to be seen is whether the secured creditors has relinquished the security or not. Because it's possible that the sum of the secured creditors has not relinquished the security. At that time, the question would arise that how the liquidator will sell the asset. If it's still possible, the non-core assets are mortgaged, or part of assets which can be excluded from the purview of the liquidation state which is being sold, then the liquidator may still go ahead. But what would happen where the secured lender having a pari passu charge over the same very asset which is being sold have not relinquished it? Then the question will come how the liquidator will sell the assets. Of course, we can still apply the principle of, in one of the judgment in NCLT, where applying the principle of SURFACE Act, it has held that if 66% of the lenders have relinquished it, it's binding on the balance 34% also. But that principle will apply only in a scenario where the secured lender have a charge on the main core asset, which can't be excluded. If it can be excluded, then there is no need to apply this principle. It can be packaged in such a manner where liquidator is selling the corporate debtor as a going concern, keeping the other assets, which is still being held by the secured lender under section 52. And in fact, in another judgment of Invest Asset, learned NCLT, Delhi actually has turned down the request of the liquidator to sell the corporate debtor as a going concern, holding it's not inconsistent with the provisions of the code. Though, of course, this matter is pending before the NCLT, which we'll see in coming times actually. And they have stayed this order itself. So the question comes how to make going concern work. Identify the business assets, undertaking and non-business assets like core assets and non-core assets. Marketability, demand, feasibility, and value maximization should be kept in mind. Explore options and permutations and combinations to identify all assets that can be sold as a going concern and those that can be sold separately. So there are few still questions in a sale of a corporate debtor as a going concern, which maybe in a coming time, the code would be amended or more clarity will come with the more judgments, where incorporation of a meaning of a sale going concern and business as a going concern and situation where such sale should be affected, treatment of liability of the employees and workmen in a going concern, and extent of statutory power under which the adjudicating authority can pass order or grant benefits. There is nothing equivalent to section 31 of the Insolvency and Bankruptcy Code in case of a liquidation proceedings. Because what happens is, when resolution plan is approved, section 31 says it's binding on all the stakeholders. But when it's liquidation sale, there is no similar provisions. So what the liquidator is required to do, ordinarily it doesn't need to approach the adjudicating authority seeking any of the order. It merely issues the confirmation of sale certificate and the sale is confirmed. But there are several benefits which goes with the corporate debtor as a going concern. Possibly there are some rights which is being held by the corporate debtor. There are concessions, there are permissions, there may be licenses which the corporate debtor is holding. In section 31, all this have been protected, but no similar provision is there in liquidation. Once it is done, there should be more clarity in coming times where these benefits of 31 should be given to the company when it's being sold as a going concern in liquidation itself. That's all on this aspect.
Yeah, thank you, Sandeep ji. Both this topic actually required a detailed discussion. And let me compliment you that you have covered both the topics in a very short period of time and very minutely you have discussed both the topics. But before I take up the question which are there in the chat, just one question which comes to my mind regarding this sale of the corporate debtor as a going concern, that what liability can I sell? Actually, what liability can I transfer? When we talk about liquidation, so every liability is a claim before me, which has to be settled with the consideration I receive from selling the company as a going concern. So what liability then should I sell actually? Does that mean that there is no extinguishment of the past liability? Even if there is no claim in that regard, and if there is a claim, then it has to be paid with the consideration. So how this go about it actually? And without transferring the liability, will there be a sale of the company as a going concern? Only the asset.
Correct. Actually, I'll just give you a recent example. You'll understand everything. We are advising a liquidator who has been in this situation where we are selling the corporate debtor as a going concern. In that, there are several claims which have been filed by the creditors, and one of the claim has been filed by the lessor. Lessor says that we have a right under the lease deed itself, where you need to pay us the entire amount, otherwise we will cancel the lease deed. And lessor is being a government authority, has given this land on the lease, and on that land, actually, superstructure has been created. Superstructure has been mortgaged with the lenders, but land has not been mortgaged. Land still remains with the lessor itself. So when we were selling, actually, this question arose that what we are actually selling in those scenarios. We are selling the superstructure plus leasehold rights. So we were in a situation where if we take this call that we are settling all the claims of the lessor, then the stakeholders were not agreeing to. And because it is a huge amount pending with interest, with penalty, there are a huge amount which was pending. If we are not settling, we can't go ahead. There was an apprehension that the lessor may terminate the lease also under the lease deed terms. And another interesting question is, lessor's right may have, of course, this is again a question which will be considered at a relevant time. Lessor right may have a priority over the rights of the other secured lenders. So at that stage, what we have done is, we have packaged in such manner that the dues of the lessor has been excluded from the purview of the liquidation. We are in the asset memorandum specifically excluded, saying that the buyer will have this liability, it will have to settle by the buyer itself. What we are selling is the superstructure, corporate debtor is going as a going concern, then this liability has been excluded from that, and that will be taken care by the buyer. So to answer your question, as IBBI has accepted this, that yes, you can package the assets as well liability, you can exclude from the purview of this also few liabilities. So the liability which has been excluded, that will not be settled from the amount of consideration which we are receiving against that. And liquidator has its right to consider that for maximization of the value.
So this is basically a specific case where there was a liability. Now, when there is no liability, still it can be called selling a corporate debtor as a going concern under section maybe, or a scheme under section 230. If there is no liability identified actually, other than the stakeholders which will be paid from the consideration.
Correct. If there is no liability, then of course it will be settled from the liquidation estate itself. That's the discretion which has been given to the liquidator to consider in each scenario. I can understand if you say there are 10 stakeholders, all the 10 stakeholders are being taken care. Once the company, see what happens is when we are selling the corporate debtors going concern, we are putting the entire corporate debtor in the liquidation estate. We are selling it, the amount comes, we are settling all the stakeholders. We can't differentiate here this situation. If you are settling one stakeholder, you'll have to settle with all the stakeholders on a similar footing. But that will not be a situation where stakeholders stand on a different footing altogether.
Few questions from the chat box. We'll take up one by one. This is from Raj Singhania, where the COC with a majority of 92% passed the resolution under Regulation 39C to sell the company as a going concern. Can any member of the COC who has assented to such resolution can have the option to exercise his security interest under Section 52 and not prefer to relinquish that security interest?
Okay. See, to answer this straight away, let me just tell you, Section 52 is provided in the code. Regulation 39C is provided in the liquidation regulations. So regulations cannot control the rights which have been conferred by the code itself. Whether he has said that to sell the corporate debtor as a going concern, it doesn't mean that he has relinquished his rights under 52 itself automatically. Rights under 52 stands on a separate footing where a special power has been given to the secured lender to take away the assets, but it doesn't mean that he has recovered his entire dues. There is still a possibility that he may not be able to recover his entire dues, and for a balance claim, he's still coming under 53 somewhere down the line. So 52 gives a separate and independent right to the secured lender, which has to be interpreted as per the provision of 52 only.
Now, one question says, please throw light on claim in respect of funds, gratuity and provident in the matter of Mr. Savan Godiwala, the liquidator of Lenco Infratech Limited versus Zapala Sivkumar. This is a bit specific, case specific, if you want to take this question right away.
Oh, I'll have to read this judgment, actually. I have not read it.
Okay, so. Okay. We'll go to next question. What about the carried forward losses, income tax losses? I mean, yes, this is pertinent question that when we are selling the company as a going concern, so what happens to the carried forward losses, whether the new bidder who takes over the company will be eligible for all these benefits such as carried forward losses which are there, subsidy which are there, which was there actually when not been.
That's exactly I covered. Actually, when resolution applicant is taking, he is regulated by resolution plan and section 31 comes to his rescue. Unfortunately, no similar provision in liquidation. If we are selling the company as a going concern in liquidation, then you need a specific order from the adjudicating authority. Without this, I cannot see any reason that the buyer can claim it from his own. You need a specific order on that actually from the adjudicating authority. Automatically, it will not be given. Like Topfer judgment. If we read the Topfer judgment, that's a recent judgment and a very good judgment by NCLT Mumbai, where they covered all the issues. What concession, what benefits can be given, what cannot be given. Of course, this question will come whether the NCLT can give this kind of benefit or not, because earlier the NCLTs were giving this benefit, but recently, in view of the embassy property and other provisions, they are saying you need to approach before the appropriate authority itself. Even in resolution plan, where it is so mentioned, and we go before the NCLT, NCLT says you go before the appropriate authority only and claim this benefit.
But now the recent Supreme Court judgment has clarified that yes, regarding the past dues, it is very clear that your RA is not required to go before any authority. It is automatic that
anything related to insolvency and past dues, those are settled. But any additional benefit or concession which you are seeking is, which are within the purview of a separate authority, that cannot be granted by the NCLT.
Mr. Raj Singhania has a few questions. I think, Raj, you can unmute yourself. If you can ask directly to the speaker.
Yes. Hi, Sandeep ji.
Yes.
Am I audible?
Yes, please.
Sir, my question was relating to the PF dues. What should be the treatment of the claim of PF or gratuity wherein the operations in the plant is closed since last 3 years and employees have filed claim with the resolution professional or the liquidator with regard to their dues, but with regard to the claim of the PF is concerned, it is being filed by the PF authorities.
No, correct, sir. That's what I actually earlier pointed it out. There are two scenarios there. Number one scenario is because the certain dues are pending to be paid by the corporate debtor to the fund. Then in that scenario, fund comes and files a claim. So another question is whether the employee can file the claim on behalf of the fund or not. That unfortunately has not been dealt with, but having said that, because employee will be claiming those funds from the Provident Fund itself. Therefore, if the Provident Fund has filed this claim, then the first duty becomes is to replenish that fund, Provident Fund, and pay off the entire amount to the fund itself. Once you pay off the fund, then after that, even the employee cannot claim that amount because you have made the entire payment. And in view of 36(4), as has been interpreted by NCLT, NCLT, which has been upheld by the Supreme Court, but not in so many words, with no reason finding. At this moment, what would happen is, as far as employees' dues are concerned, that will be treated as per 53. But as far as Provident Fund, pension, and gratuity fund are concerned, that will have to be paid in priority outside the liquidation estate and in full.
And now, if the plant is not in operations during the CIRP as well and prior to this, no service is being provided to during the CIRP, so workers are not putting up any claim for this CIRP period. Can the PF authorities make a claim for this period?
See, that depends whether the employees are still on rolls or not.
If employees are still on rolls,
then of course, if employees are still on rolls, you are still paying the salary, it becomes a part of.
No, I'm not paying salary, neither they are claiming the salary during the CRP period.
No, but I mean to say is, in the balance sheet also, you will be keeping a provision for that salary. Because if they are on roll, you are keeping a provision. If you are keeping a provision, you are deducting that. Now it becomes a part of the CRP cost. Otherwise, what would happen is liquidation order is itself amounts to discharge of the services of all the employees.
Yes.
You have not done it. If you are still on the keeping them on rolls and taking the services, maybe they might be sitting at home itself. They are not coming to the plant. But in practical, actually, you are still showing them as your employees. Then, of course, you are taking over the liability. You should have taken resort order in the section 33 itself. Because section 33 says the day liquidation order is passed, the services of the employee stands discharged.
Okay, thanks for the clarification.
Mr. Ramesh, KS Ramesh wants to have some question. Mr. Ramesh, you can unmute yourself.
Hello. Hello.
Yeah, Mr. Ramesh, please
Just,
go on.
just now you're referring to liquidators' rights of a leased assets. If they are not mortgaged, they don't have. But suppose the leased assets are mortgaged as a lessee, if they are mortgaged to the banker, what would be the rights of the liquidator or the RP for that matter?
See, what happens is when you are, whenever you see that any asset which is mortgaged to the lenders, which is the leasehold rights, then generally it is done on the basis of an NOC given by the lessor. And in NOC, there is always a provision that the lessor right shall have a priority over the rights of the secured lender. So lessor will always have a first priority in view of that NOC. There are judgments under the earlier acts, not under the insolvency code, where they have held that everything is regulated by the terms of the lease deed, and lease deed shall have a priority because all rights are other rights of the secured lender are subsequent and subject to the rights of the lessor.
Sumitji is also there. He was the liquidator in Gujarat NRE, and he can, if you, Sumitji, I would request him that if he can throw something brief about the selling the corporate debtor as a going concern, in addition to what Sandeep Bajaj has already spoken. Sumitji, are you there? Okay, Mr. Garg, Mr. S.K. Garg, you can unmute yourself and ask your question, Mr. Garg. Mr. S.K. Garg.
Yeah, I am trying to unmute my.
Yeah, you are audible.
It's audible.
You are audible. Yeah, audible. Please.
Hello, sir.
Hello, Mr. Garg.
Sir, I have query on limitation law. So suppose I am taking one example. A loan was granted to a company in 2015, and the check was returned dishonored in 2018. Time to time, company pays the interest amount, and now the company wants to file Section 7 application upon them, and the amount is exceeding 1 crore rupees. Is it possible date of default will be counted from date of dishonor of check or from the very beginning?
See, what happens is date of default remains the same when the default has already occurred. When we talk about the check, it may amount to acknowledgement under Section 18. When you are serving the interest, it amounts to part payment under Section 19 of Limitation Act, Section 18 of Limitation Act and Section 19 of Limitation Act. So if any person has given a check or was serving the interest or even the deducting the TDS on the interest and depositing that, even that amounts to acknowledgement. In addition to that, books of accounts will also be reflecting some liability that also amounts to acknowledgement. So if we do all this, of course, subject to reading in detail on the facts of it, what seems is it will be within limitation and it can be filed. See, in any case, filing, there is no stoppage. One needs to consider whether it's barred by limitation, whether it can be admitted or not.
Yeah, when the check was last returned, 3 years has not been expired. That's my.
What needs to be seen is another thing is the admission should also be within 3 years. If the debt is of 2011 and a check is given in 2018 and there is no acknowledgement in between, then everything goes. Then it will not create a fresh liability. Time is the claim is still time barred. So what needs to be seen is acknowledgement. If acknowledgement is within 3 years, it gives a fresh period of limitation from that date.
Yeah, in this case, check in the amount was granted in 2015 and check was received within 3 years and default happens within 3 years.
Then of course it seems that within limitation because it amounts to acknowledgement. And you are saying that you are serving the interest also.
Yeah.
Thank you, Mr. Garg.
Thank you, sir.
We'll take two questions. Last question I think is one from Ms. Pragya. What happens if the PF proceedings are pending during the CRP and liquidation? And second question is, can a liquidator take over the charge on the asset which the corporate debtor is taking rent till the clearance of debt on such debt, and such debt has been secured by the bank? So please, something I think.
I'll just answer the first question. Okay, during CIRP, that's another question. Interesting question is When we talk about during CIRP, section 14 provides there will be a stay of all the proceedings. It doesn't talk about the legal proceeding, it talks about all the proceedings. So in view of section 14, even the proceedings which are held by the EPF department, the Provident Fund Department, even those are called the proceedings because it ultimately result into the amount which creates a liability. They are adjudication because it's a quasi-judicial body, and these are considered as the judicial proceedings, and it results into the liability upon the corporate debtor that it ought to be stopped. But having said that, there is another point of view also. There are both the point of view. Another point of view is what PF department is doing is they are just adjudicating, assessing the amount which is to be recovered from the corporate debtor. So internal assessment should not fall foul of section 14. So there are 2 points of view which will be tested as per in a relevant case. But once the liquidation starts, liquidation stops is only the legal proceedings, which the Provident Fund Department's internal assessment proceeding may not be called a legal proceeding, and they may continue to assess the amount. Once they assess the amount, they can still claim the amount, and once they claim the amount, then it may not be permissible for the liquidator to sit on the amount which has been adjudicated upon by the adjudicating authority. Then you may need to file an appeal before the appropriate forum, and NCLT may not be in a position to go into this question. And a second question, sir, if Mr. Lohia, if you can repeat the second question.
Yeah, yes. Second question is basically, can a liquidator take over the charge on the asset, which the corporate debtor is still taking rent till clearance of the debt? On such debt has been secured by the bank. Basically, I'm not also clear about the question. Basically, he's asking that whether the liquidator can take over the particular property which is on rental basis and in the possession of the CD.
No, correct, because it's a duty of the liquidator to take over all the assets of the corporate debtor, whether it's owned by corporate debtor or whether it's a rented property being held by the corporate debtor. But having said that, the liquidator needs to decide whether it actually needs that asset or not. If after taking the possession it doesn't need, it can still cancel the lease deed and give it back, but he'll have to take the possession. There is no doubt about it.
Right. I think with this, the question will go on. And regarding the PF, I must say that still my question still remain unresolved. That what we do about this PF during the CRP and liquidation. Still, I being the liquidator of the resolution professional, I still don't know where to go.
As per all the judgments which have been passed, it will have to be paid in full. I have several grounds which needs to be raised before the
No. I totally appreciate that.
Analysis of this, but as per judgment, if you ask anyone, you please make sure it is paid in full.
Yeah. That is why you see the bankers and financial institutions are not filing cases these days. They are saying that it's better to recover under SURFACE, why to go under IBC when our not a secured. Yes. So one thing more, even during the CRP, whether this PF dues will take priority over the dues of the financial creditor over the secured asset?
No, sorry. What do you have to come again?
Even during the SURFACE sale, will this dues of PF will take priority?
No, that's exactly what has been said by the NCLT. NCLT says even before 52.
But even that is not happening. Right now, the banks are selling their secured asset directly without even paying any amount to the employees' welfare dues. So they are doing it right now.
That's what I pointed out to the judgment of Chennai or Kochi. Chennai or Kochi. Kochi. NCLT Kochi has said before 52 also you need to pay the dues.
Okay.
So that's what I'm saying. Because in any case, 52 comes into existence because they are taking away the assets and it will not form part of the liquidation estate. But unfortunately, NCLT Kochi in a recent judgment, I'll share that slide also and judgments with you, where it says that before 52 also you need to pay the dues. It's a gray area as of now. It will have to be considered that it needs to be settled by the Supreme Court. But present situation is this only. And if I can just read one para. Hence, EPFO need not to file Form G before the liquidator. It is also seen that the EPFO has got first charge over the assets of the defaulter and its priority of payment over the debts in as per Section 11 of EPF and MP Act.
Yeah, perfectly right. In the current situation, that is what we all have to do as a liquidator and resolution professional, that clear of the dues. Whether you get your fees or not, that is a secondary matter. Okay. So Mr. Balbir Singh sir has once again joined us with us. And thank you, Sandeep ji, for your wonderful deliberation. And I know the question will keep on coming on both the three topics which we discussed today. So Sumit ji is not there actually. I think he's not responding. So may I ask Mr. Anup Kumar Banka to kindly propose a formal vote of thanks to our both the speaker for this today's lecture meeting, Mr. Sandeep Bajaj and Advocate Balbir Singh. Both have spoken wonderfully, and thank you to both of you from the end of Association of Corporate Advisors for coming with us and answering a lot of our questions. So Anup Banka, over to you.
Respected Chairman of IBC Committee, our most valuable invited guest speaker, Mr. Balbir Singh and Mr. Sandeep Bajaj, and ladies and gentlemen. Good evening to all of you. Thank you, each one of you, for being here with us today. It is my privilege to propose a hearty vote of thanks on behalf of ACA. I would like to express my profound gratitude to Advocate Balbir Singh for his excellent deliberation and sharing with us his valuable thoughts and opinion today and making this virtual seminar interactive and meaningful. Thank you, sir. We are really enlightened. As a token of love and affection, we are sharing e-memento to you. Can you share, Mr. Loya, e-memento by sharing the screen?
I'm doing it.
Okay.
Let me do. And I'll just make a small corrections. Sir is a senior advocate. I repeat for all the learned audience. Sir is a senior advocate and is an additional Solicitor General of India, Supreme Court. So please stand corrected.
Don't worry. I think before being a senior advocate or the additional Solicitor General, I'm advocate. So perfectly all right. It doesn't matter. And I thank you everyone and the association for having me here, and thank you, Sandeep, for making me part of it. And I'm very, very impressed by seeing people who are so curious and they are practically involved in the work. And I wish everyone very good luck.
Thank you for joining, sir.
Thank you.
Now I would like to express my profound gratitude to Mr. Sandeep Bajaj, Advocate, for his excellent deliberation and sharing with us his valuable thoughts and opinion today and making this virtual seminar interactive and meaningful. Thank you, sir. We are really enlightened. Sir, as a token of love and affection, we are offering you e-memento. No, can you share?
Yes. 1 second.
Now I thank all the participants who have participated in large number and making this seminar a great success. You always help us by your presence to carry out this kind of seminar. Thank you once again to all of you. Thank you. Thank you, everyone.
Thank you, Sumit ji. I just saw him in the screen. Any concluding remarks, Sumit ji, so that we can end this session?
Sumit Binani ji.
Anup ji, can you just share concluding remarks for this session? And yes, we'll be having more of this session on the varied practical topic in next few weeks. So we'll be informing you time to time when we come up with the programs, details of the programs. So Anup ji, please, you may.
Indeed, a wonderful session. ACA is really grateful to both the very, very learned speakers. The entire session, 3 hours, was completely interactive. That made the session perfect, actually. And I believe and I strongly felt that the audience out here must have been benefited by this session. Thanks to both the learned guest speakers out here. Thanks to all the participants who has actually contributed by asking your question and answers also. Thanks to each one of you. Thanks to the chairman, Mr. Jitendra Lohia, co-chairman, Mr. Sumit Binani, and all the executive committee members of ACE. Thanks to each one of you. So with this, with the permission of our learned speakers, can we end this session here?
Yes, please. Yes.
Thank you. Thank you
Thank
very
you.
much, sir.
Thank you very
Thank
much.
you very much.